Announcement of judgment of item number 1.
I forgot. Almost. Thank you. The judgment of conviction dated 2012-2023 and the orders of sentence dated 21/12/2023 passed by the Line Session Judge Namsai in session case number so-and-so are set aside. The appellant is acquitted of the offense under section 302 of the Indian Penal Code by extending him the benefit of doubt. The appellant shall be released forthwith if not required in connection with any other case. Fine deposit shall be refunded.
I do oblige.
I'd like to mention item number 6. Seeking adjournment for 3 weeks.
3 weeks. Have you taken consent
Yes.
on the prayer of Mr. R. Koy, learned counsel for the appellant? Let this writ appeal be listed after 3 weeks.
Lordship, item number 8 and 9 is a connected matter.
Okay. We'll see what order needs to be passed in 8 and 9. You be there. Orders will see.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 4. The leading counsel is out
You
of
want to
station.
withdraw?
No, Lordship. We're seeking adjournment, Lordship. The consent has been taken from the other parties as well.
Okay. On the prayer of Mr.
K. Gao.
K. Gao, learned counsel for the appellant, let this matter be listed after 4 weeks.
Oblige.
My Lordship, I beg to mention item number 21. The conducting counsel, K. Gini, is out of his station.
21.
Yes, the consent has been taken. Is it
No
counsel?
problem.
Going.
On the G. Ginny,
Yes, conducting counsel.
MS
M. J.
M. Jaram, learned counsel appearing on behalf of Mr. G.
K. Ginny.
Learned legal aid counsel, Semester.
After
Mr. Ginny
a week.
has some personal difficulty today. Therefore, press for listing of the matter after 4 weeks.
After a week. No, it's okay. After summer
After a
vacation.
week, how can we?
It's okay. Summer vacation.
After 3 weeks.
May it please your lordship, I beg to mention item number 3. I have taken the consent of the petitioner here, your lordship. We are yet to file our affidavit, your lordship.
That time you said it was sent for betting.
Yes, your lordship.
We thought we'll close the matter.
The department was a bit confused. We have called them for personal appearance and we have suggested them, your lordship, how the vetting process goes, your lordship.
Personal appearance.
Like to the office, your lordship.
Okay.
So at least 3 weeks time may be given, your lordship.
I thought he wants to appear personally. So what do you want?
3 weeks time, your lordship.
On the prayer MS TG Learned Additional PP for the state. Let this matter be listed after 4 weeks, 3 weeks. In the meantime, as as undertaken by MS Zini, let an affidavit in opposition be filed, be invariably filed in the meantime.
Your Lordship, I have certain matters to be mentioned, Your Lordship. Ma'am,
Yes.
we have just been informed that the additional PP is no more, Tado sir. So,
it?
yes, so I would like to make certain items which were endorsed to us, Your Lordship. If Your Lordship may take it tomorrow or next week.
Very unfortunate.
Certainly.
Okay, all which items?
Item number 5, Your Lordship.
5. Item 5.
Item number 5,
Yes.
item number 17, item number 19 and 20, Your Lordship.
19
So,
and 20. Okay. It is informed by MS Tijini London additional PP that Mr. Gitado London additional PP has unfortunately yesterday
Today.
obviously expert accordingly this let the matter be listed. These all these separate orders. After 3 weeks, we'll see 3 weeks. Very unfortunate.
Item number 2.
May I please, Your Lordship, they are supposed to file, Your Lordship, status reports and affidavit,
Yes.
IMC and respondent number 6 and 7, Your Lordship.
Panchayat, Lordship, I have communicated, I have written to the Panchayat. That I'm not advised for coming up. Till now,
What is to be done? Have
IMC
you
or
seen the last order?
Lordship, weekdays, Lordship.
You are there.
regarding,
You have nothing to do. Where is Mr. Jamo? Is he around?
He was
Mr. Jamo. We'll take after some time.
In fact, Mr. Jamu will no more appear for this IMC. He has been discontinued. Another Loma Kurdu,
Loma Cordo.
I think he has been appointed for IMC.
Call him. Please inform him. We'll take after some time.
okay.
We'll dispose of the matter if it is.
Okay, if it is
It's
compliant,
in compliant.
but,
Applies, Your Lordship.
So you don't want to file? You're not interested?
no, Lordship. Reply is not forthcoming. Without instruction, I cannot file.
It's your, that's why we have directed you to file. It's you to take care of that.
If not, Lordship, one last chance, maybe even after 2 weeks, Lordship.
Then in that case, we'll write. Her MS N
KN Maling,
sorry, N Malik.
KN,
Okay, and
K N Malik.
yes.
Kaninada. We just remember Kaninada. Maling we
Adept, Your Lordship.
okay. K N Maling, London Council for the petition. Next para. Although this court has granted granted an opportunity to the State Council as well as the Standing Council for IMC, not for filing affidavit as regards the status of the, what do you call it? To file this, sorry, status report. Come on. Nothing is forthcoming. Mr. It is also informed that the Mr. Jam, or the Standing Council of IMC has been changed, and Mr. L. Kurdu Learned Council has been appointed as Standing Council. Next period. As spread for by MSG at Learned Senior Government, Additional Senior Government Advocate. Further, 3 weeks time is granted to file the required status report. And she is also requested to inform Mr. L. Kurdu, Standing Council IMC. Mr. It is made clear that in the event no affidavit as regards the status report is filed on the next date, by next date, this court would proceed to hear the matter without further without affidavit.
Yes, yes. Item number 7.
May I sign, my lord?
Yes.
But here in this case, my lord, my read petition, my lord, was basically granted on violation of natural justice, my lord. Now, Planet Single Judge, my lord, applied a doctrine of useless formality, my lord. Useless formality, my lord. Doctrine of. Now, I say, my lord, that was wrongly applied in this case, my lord. I'll try to address two issues.
See, doctrine of useless formality
My lord.
can be invoked
Yeah,
in the circumstances of alleged violation of principle of natural justice only,
yes, my lord.
not
Now,
other thing.
In
If then opportunity is given, but then it doesn't have any effect,
that was not given, my lord. That is
then
undisputed.
then only
Yeah, my lord.
the useless formality theory comes in.
Can't be, my lord. Now that I believe, my lord, this has been wrongly.
You are provided an opportunity.
No, my lord. No, my lord.
Huh?
No, my lord.
And when you have admitted, no, the records indicates that you have changed the party or you have violated the party whip.
He contested against the lawsuit officially nominated.
You have contested.
No, that's why, my lord. I'll try to address
So
on
what, even if you are given an opportunity,
my lord.
what change will be there?
No, my lord.
What would be the difference?
My lord.
What will make any difference?
My humble understanding, my lord. Even if suppose I violate the whim, my lord, simply violation of whim will not get me to the disqualification, my lord.
No, once
It should be the whip should.
No. If it is established, if it is established,
Yes, my lord.
that not only violation,
My lord.
violation in the sense you have already contested the official candidate
Yes.
of your party,
My lord.
under whom you have been elected.
My lord.
What more it is required?
My lord, my humble survey, until and unless proof, my lord, there should be positive proof that I not only violated the whip, my lord, but I violated the authorized whip, my lord. Only simply violation of whip will not.
No, not only simply violation. Since the conduct of your contesting,
My lord.
the official candidate of your party,
My lord.
who has under which you have, on which you have elected as a member. What more? What proof?
No, my lord.
What more proof is required?
My humble son, before that, my lord, before finding that I violated the whim, my lord, there should be a finding that whim has valid and authorized, my lord. Until and that whim is valid and authorized, my lord, my violation will not put me into the disqualification, my lord. They just settled down, my lord.
Did you not contested the official candidate of your party?
Is I contested, my lord.
Then?
I contested, that's why, my lord, my humble submission, my lord, simply contesting against the person, my lord, official candidate, it will not put me into the disqualification. It should be, there should be a proof that I violated the authorized OIM, my lord. Now, here is a case, my lord, there is no positive evidence, my lord, that I violated the OIM, my lord.
This is what more evidence you want? If you have contested against the official candidate of your party, what more proof you want?
No, maybe I'm not put in properly. My humble submission, my lord,
Understood.
law is certain, my
There is no-
before that, my lord, before that I violated, my lord.
Prove. That is what you are trying to say. And you have not been allowed to lead an evidence to disprove the
Dispute
allegation.
that are unauthorized, my lord. Because due to the violation of national justice, my lord, I could not prove that that was unauthorized whip, my lord. Pass, my lord.
No, you could not disprove, but it is proved that
No,
you have
that was-
contested
that-
against the official candidate.
No.
That's all. It's more than enough.
No, my humble son, my lord, give me 4 5 minutes, my lord. My lord, see, my lord, before put me into disqualification, my lord, yes, before proving I violated evidence, my lord, there should be evidence that I violated the valid with my lord. Authorized with my lord. Until then, that is not, my lord. The apex court say, my lord, simply violation of whip will not put me into disqualification, my lord. First,
It's not a simple violation. It's an established a fact that you have contested.
No, my lord. That yes, I submit, my lord. There is no record as such that I violated the authorized with my lord. Pass, my lord.
Forget about it. Violation will come later. Did you contest?
Yes,
against
my
the
lord. I
official
contest, my lord.
candidate?
I
Then
contest, my lord.
Better answer.
No, my lord.
If you say.
Even if I contest, that's why, my
You
lord.
say that the I have not contested. Even if they allege that you have contested against the official, then you may be allowed to.
Now, second, my lord. Second, my lord. Second, my lord. Even if, my lord.
First, once until you cross the first hurdles, will not go beyond.
No, my lord. First, I will try to address those by some citation, my lord. I say, my lord, until and unless.
Forget about the citation. Citation will come later. First, we'll have to.
Yes, my lord.
Facts will be-
Accepted pay, my lord. There was a whim, my lord, and I contest against those, my lord.
Maintenance there. Rate appeal dismissed.
No, my lord. Before that, man. That apart, my lord. My humble submission, due to the violation of this national justice, my lord.
What natural justice?
Give me 2 minutes, my lord.
See, if your notice is given, if you are given an opportunity, what more?
I would have
Can you say
defended, my lord. This
by evidence, can you say that you have not contested against the official
no,
candidate?
not only that, my lord. My lord will say not only that. If I have been given opportunity, my lord, I have contest before the DC that this complaint itself was not maintainable. My lord. It is after only lapse of 15 days, my lord, that complaint is maintainable, my lord. Here is a case, my lord, on the date of complaint, my lord, 10, my lord, the complaint is within 2 days, my lord, this complaint is, my lord. Where the law mandate is after 15 days, my lord. Now, before 15 days, there is a provision which allow the political party to condone, even if I will violate it, my lord. But that was not given, my lord. Therefore, violation of this national justice, I also suffered legal injury, my lord. In this case, my lord.
So where is the provision that condone
Yes, my lord.
before 15 days?
My lord, will kindly turn to page number 51, my lord. It starts from 50, my lord, 6, my lord. 6, my lord, 1, my lord. My case falls under 161B, my lord. In case of falling under clause B of subsection 1, after expiry of 15 days, my lord. It can be only after 15 days, my lord. Now, here is a case, my lord. On the day I violated the OIM, the complaint was filed on that day itself, my lord. And my lord, turn to page number 49, my lord. This is the 3, my lord. Section 3, my lord.
What are you trying to say?
So,
What you are trying to say?
I say, my lord, the complaint, my lord.
Complaint has to be within 15 days.
Only after 15 days, my lord. In case of case post under B of subsection after the expiry of 15 days, my lord. Now here is a case, my lord.
A complaint that member has become subject to collusion under section 3 may be made by a member or a political consent of the authority. It doesn't make any sense.
Yes, my lord. My lord, page number 49, my lord. This is the provision section 3, my lord.
Huh?
Past, my lord, will kindly turn to page number 49, my lord. Section 3, my lord. One, my I am reading, my lord. Subject to provision of section 4.5 and 6 of member being in a political shall be disqualified for being such member. One, my lord, if he voluntarily give up his membership of such political party. That is not applicable in this case, my lord, if we go by impugnator, my lord. Second, my lord, or B, my lord, if he vote or abstain from voting in or intentionally remain absent from any meeting of the Jilla Parishad Ansal Samiti or Gram Pansat contrary to any direction issued by the political party to which he belongs, or by any person or authorized authority authorized by it in this behalf without obtaining the prior permission of the such party. My lord, kindly note also here, my lord, the OIM should be authorized person, my lord. Such political party within 15 days from the date of voting of such abstain or abstain, my lord. Now, they are condemned, my lord. Now, this, my lord, directly turn to page number 15, my lord. This complaint violation of under this section 3(1)(b), a complaint can be lodged in section 2(1)(b), my lord. On 2(b), section 1, my lord, a complaint that a member has become subject to disqualification under section 3 may be made by member of political party to the member secretary of the concerned local authority, A, my lord, in case of falling under section A of section 1, subsection 1, after member given at the membership of political party. That is not applicable to me, my lord. B, my lord, in case of case falling when the allegation of violation of
The complaint was not against after the expiry.
Before
the expiry of 15
before the
days.
experiment. On the 10, the meeting was held. On the 10 itself, complaint was lost. That is matter of record, my lord. On the 10 itself, complaint was lost, my lord. My lord, you can turn to page number.
It was what?
Complaint, my lord. This complaint under this section 2 was lost on 10 itself, my lord. 10/1/2026, my lord. When the whip was violated, my lord.
When the voting was on. or the proceeding was
Yes,
on.
my lord. On the same day, my lord. Now, therefore, my humble submission, my lord, due to the violation of necessity, I could not take those legal injury to me, my lord, before the concerned authority, my lord. Now, therefore, my lord, this.
Who will come to the court without legal injury?
Yes, my lord.
Who will come to the court without legal injury?
Yes, my lord. That's why, my lord, before the land is single, as my lord, that aspect was not concerned. As my lord, the law of useless formality, my lord, can be able only when there cannot be substantial sense, my lord, and undisputed fact, my lord. Here is a case, my lord. Suppose if I was given an opportunity, my lord, I would have taken a plea of unauthorized, and I have taken a writ petition also, my lord. That was unauthorized with my lord. Now, to that extent, I have annexed whole constitution of BJP, my lord. It say only the president as a general secretary, my lord. Here is a case which was issued by the Mandal president, my lord. Until and Supreme Court said, until and that is shown to be authorized by some person, authorized person, my lord. They are simply violation with my lord.
Huh? Is that? Yes, sir. Police notice.
Okay.
Heard Mr. Learned counsel for the petitioner. This intercourt appeal is directed against the judgment directed against the order dated 12/06/2026 passed in WPC 88 of 2026, by which the writ petition of the petitioner has been dismissed in respect of as regards the disqualification of the petitioner under the Arunachal Pradesh local authorities within bracket prohibition of depiction within bracket Act 2006 or what? 2003. 2003. List of issue notice returnable by 4 weeks. Mr. You are for?
Lordship, 1,
3.
2 and 3, Lordship. Sorry, 1 and 3, Lordship.
Mr. Estapin Lana, Senior Government Advocate, accepts notice on behalf of respondent 1 and 2, 1 and 3.
1 and 3.
And as such, no formal notice need be served. However, extra copies be furnished to so-and-so. Land counsel for the petitioners to take steps for service of notice upon respondent number 2 by registered post as well as by usual process.
I pray, my lord,
Where is the order?
order, my lord,
What is the order? Order of disqualification.
disqualification.
When it was?
But it was issue on my
6th
lord.
of February.
But then no election is yet, no election is done, my lord. So, my lord, in terms of public interest also, my lord, the post should be filled up, my lord. As no new election is held, my lord, I need to be protected, my lord. Election is yet to be held, my lord. In terms of this impunity, my lord, I need to be protected, my lord.
Yes, what do you say?
Lordship, so far,
That is for the public interest only, my lord.
within, after passing of 15 days, Lordship, complaint that issue is not pleaded case in the writ petition also. It's not a pleaded case, Lordship.
Yes, my lord, I do, but I humbly will, my lord, this is a matter of law, my lord. I can be raised
It
any
has been
at any
discussed
stage, my lord.
long time back, so Lordship.
No, my lord, but no, no, there is no election. is held. No election. my
There
lord.
no re-election.
No,
That
my lord.
part,
Re-election.
Lordship, I have not.
Re-election.
taken
We'll
any-
say, considering that prima facie, the provisions of law of so-and-so Act 2003 and also considering that an adequate opportunity prima facie appears to have not been provided to the petitioner, the appellant, as well as the democratically elected member should not be unseated, ordinarily unseated with a due process of law. Till the next date. What interim prayer?
My lord, I pray stay of
Status quo.
6/2/2026, my lord.
Status quo can be given so that no press election is conducted.
Status quo.
I pray 6/2, my lord, 2020, my lord. Stay of 6/2/2026, my lord. Order by the
That may not be,
Speaker.
that may not be.
So, my lord,
Status quo as on
Status quo.
today shall be maintained.
my lord, my humble submission, my lord. Yes. In terms of,
Let us see.
this is democratic, my
If-
lord.
no, if-
There is one,
No,
Now-
status quo.
now status quo, if my lord, it say, my lord, I'll be not, I cannot assume my office, my lord.
Huh?
Now, I
The
cannot assume, my
petitioner's
lord. Now,
apprehension is that if press election is conducted, Lordship, then it may Lordship affect the
you can say, my lord, if not, if till that no press election conducted, my lord, then it can be stay, my lord. Otherwise, if a press election, my lord, that will know, my lord, can make some observation, my lord. 6 my lord, because my lord, my lord,
This is-
this is
there will be
this is my lord
election.
pertaining to Panchayat, my lord. Now, that is for any development activity, my lord, there's a representative, my lord. I am the chairperson, my
what?
lord. I am the chairperson, my lord, elected chairperson, my lord. Now, this is for in the Panchayat also for any development activity. My
Which
assuming of
political party?
no, my lord. I'm from. I say, my lord. I say this pertaining to village, my lord. Any development activity, my lord.
You are a chairperson.
Yes, I'm the
Gram
chairperson.
chairperson.
Yes, my.
It's okay. Other grams are there.
No, my lord. My lord, no, my lord. In term of now the law, in term of that can be only to the chairperson, my lord. Now through the gram chairperson, my lord. Now in absence, my absence, there is no new chairperson elected, my lord. That ultimately public will be suffer, my lord. Therefore, my humble submission, my lord. No prejudice. Otherwise, also no prejudice because by staying this order, my lord. And if they circuit, I'll ultimately need to become, my
It
lord.
is clarified that if the petitioner is functioning as a chairperson, a Gram Panchayat chairperson, as on that, he
He
shall be allowed to continue till the next day.
High level.
Is on that. He's not functioning.
Otherwise, on face lawsuit, disqualification order is already there lawsuit, which was impugned in the writ petition lawsuit.
That's why we'll examine
Lawsuit
it.
at best protection can be given.
Well,
No press election is conducted.
If press election is
If
conducted,
press-
my lord, I have,
Press election is
I
conducted,
would
then
not have made such
he may be
prayer, my
prejudiced
lord.
also.
Otherwise, my lord,
Okay.
for the public, it is necessary, my lord.
Public,
Yes, it is a-
public interest.
My lord, so-
You really want to serve.
Yes, my lord, the court, ultimately, all the development activities is routed to the chairperson only, my lord.
Thank you.
High level, my lord.
Item number 8 and 9.
Is prayed for by land council for the parties. Let this matter be listed along with WA. Let these writ appeals be listed along with WS 27 of 2026. Right?
No, your lordship.
W-
No, he said it's a similar matter.
That is before single bench, your lordship.
Huh? What is it? What you have said? You have mentioned item 9 and 8 and 10 are similar.
8 and 9, 8 and 9, your lordship.
Huh?
As per the last order, service is completed and matter was supposed to be listed for admission hearing,
Okay.
your lordship. So this matter can be listed for admission hearing after.
That's all. Why you are saying that it should be listed along with that thing?
No, 8 and 9 only. I was mentioning 8 and 9. 8 and 9, since water connected better therefore.
Okay. Our MS, who is for petitioner? The appellant. Mr.
K. Lawrence, lordship.
K. Land Council appearing on behalf of Mr. T.T. Lal, Senior Counsel for Appellants. Koba. And
In item number 9, your lordship, for appellant.
MSN Anju, Land Council for Appellant in W. You just write that, huh? W and so and so. As well as Mr. Arko. Correspondent number?
1 and 2.
And
I am for private respondent, except 25 and 26.
P. M. Karbak, Land Council for respondent, private respondent. We'll say private respondent. Except 25 and 26.
Yes, madam.
Mama. Next para. Services are complete. List for admission after 3 weeks.
Obliged.
Obliged.
Item number 10.
Please, your lordship.
Yes.
My lord, this matter was pending for a long time because there was a submission made on behalf of the respondents that there is a similar matter pending before Honorable Supreme Court.
Yes.
Now, I'm told that the order has come. So the matter may be listed for hearing on after this break.
Lordship. The similar matter pending before Apex Court has been disposed of, your lordship.
Saying what?
That there's no provision for any re-evaluations. There's no provision for any re-evaluation of the answer script, your lordship.
Re-evaluation of the
Yes,
transcript.
re-evaluation of answer script.
Basically, now the case is in ICU. So, my lord, may list it after break. May, if my learned
It will be again formality.
my lord, I would still like to see, because
This is a similar matter.
It is.
according to me, it is not exactly on the same facts, but
You just
Okay.
share with.
Yes, I have.
It is submitted by MSN Anju, AA Anju, Land Council for the respondent.
For commission, your lordship.
Respondent APPSC. That similar issue as regards the re-evaluation of the answer script.
Lordship.
Oo,
has already been settled by the,
DB ito na.
as has been decided by the Honorable Supreme Court. Lister. Therefore, nothing remains in this writ appeal. Lister. However, MS Endang and London Council for the appellant submits that although the matter appears to be in the ICU, but then he would like to argue it out on some other day, according to press for listing the matter for hearing.
A fixed date may be given, Lordship.
Consider the above. Don't
If-
say ICU, huh?
4th of August, Lordship.
Consider the above, huh? Let this matter be listed. For admission, we'll dispose of at the admission stage.
Oh, my lord.
Admit-
4th of August.
4th of August. Okay.
Yeah. Obliged.
It's a hearing day.
Yes,
Yes,
Division
yes,
bench.
it's a Tuesday.
Tuesday, huh?
Yes.
Item number 11.
The service is still awaited.
Await service report. Mr. Arko, Learned Council for the appellant is present. List after 4 weeks.
Item number 12.
Yes.
Lordship, service is completed, but still we have received affidavit of opposition respondent mode 2 and 3,
Huh.
and rest of the respondent are not yet to file.
Who are rest of the respondents? What's the issue?
Issue is that they claim compensation on PMJ's road and they have alleged that there is no environmental clearance, forest clearance.
Okay.
There are two issues.
They are seeking compensation under PMJSY
Yes,
project.
on behalf of so many unspecified victims or affected persons. Otherwise,
And other second is
second is that well,
there's no
forest clearance.
okay. So who has to file? Who has not to file?
I
Who has
have
filed?
already filed. 3 and 4 filed.
3 and 4.
State has already filed.
Yes, Lordship.
No,
Then
RWJS.
you
My
have to
lord,
file
this-
or not?
Sorry for interruption, my lord. My lord, your lordship is aware, my lord, this PMGSY, my lord.
Hmm.
There is, my lord, no provision for land compensation, my lord. We all are aware of that, my lord. And this is basically executed by the RWD department. My lord, whatever affidavit they file, my lord, we will be basing on that. my lord.
Mr.
BCO on
BC
behalf of
Learned
T.
Council
Tapak.
appearing on behalf of T. Tapak,
Yes,
Learned
Lordship.
Council for the petitioner. Mr. M. G. Tarak, Learned Standing Council RW submits that an affidavit on behalf of the department has already been filed. Mr. Arich Nabab, Learned Additional Advocate General submits that the state will go with the affidavit of the affidavit. They go with the affidavit of, filed by the departments. Then you said submits that no separate affidavit is required to be filed on behalf of the state, as the affidavit filed by the department would suffice. List of MS. Huh? Why Learned Council appearing on behalf of Mr. T.M. Kato Learned DSJ press for and is granted further 3 weeks times to file affidavit.
Item number 13.
So many things.
Lordship, we received the Parawise comment. We'll be filing our.
Heard, Mr.
Tita.
Huh?
Tita. I'm appearing for
Tita.
Mr. N. Rama on behalf of petition.
Tita.
Yes, Lordship.
Tita Nagar.
The Cheetah.
Tita. Learned Council for the Learned Council appearing on behalf of
N. Rama
N. Rama
for the
Learned Council
petitioner.
for the petitioner. Next para. On the prayer, Mr. Arko Land Council for the state respondents. Who else, sir? You want to file? As well as so-and-so. Waigao, huh? Land Council appearing on by Mr. M. Kato so-and-so, Land DAJ. For the 3 weeks time is granted to file affidavit. Positions. MSK T. Wangmo Land State Council is present.
Item number 14.
This is also PIL. What PIL is this?
May I, Lordship, I may be allowed to press a step for respondent, in respect of respondent number 225. I may be allowed to press it.
Mr.
B. Sibo.
B. Sibo, Land Council for the petitioners.
Yes, Lordship.
Is granted a week's time to take precise steps for service of notice upon respondent 225. Mr. Aris Nabo, Land Additional PP, and Mr. MS Waiga.
He's also there, Malot.
So and so for appearing for her. M. Katol and the so and so. As well as Mr. Opada, Special PP.
Malot.
Special PP, SCB.
ACB, Malot.
ACB. Granted for the 3 weeks time to file affidavit in office.
Item number 15. Mr. Arko Land Council for the appellant is present. What service report? List after 4 weeks. Item number 16.
May I, Lordship?
Yes.
Lordship, the steps upon respondent number 17 is completed, Lordship.
Ah.
And however, we were not allowed to take steps upon respondent number 5, 6, 7, and 10, Lordship. So we were allowed to take steps upon them.
Yes, for service of notice upon respondent is not yet taken. You have not taken steps for 17.
Respondent number 17 is Union of India, Lordship, and it is represented by the DSGA, Lordship. So
Her MS?
M. Bori.
M. Bori Land Council for the petitioner.
Yes, Lordship.
Petitioner. This is what? Taten Sapa.
Yes, sir.
Sapa.
PIL.
Is a lawyer. Petitioner is a lawyer.
No, Lordship.
Okay. Office note dated 24/06/2026 reflects that no steps has been taken in respect of respondent number 7. How about the respondent 7? Isn't respondent 7 is the Union of India?
17 is the Union of India.
Union of India.
Yes. Here.
Which is being represented by MS Waiga Land
17.
Council appearing on behalf of Mr. T. M. Kato Land DAJ. Huh? No, 16. Okay. As spread for by MS Swenso Land Council for the petitioner. A week's time is granted to take steps for service of notice upon respondent. Fresh steps.
Yes, 5, 6, 7, and 10.
Granted a week's time to take press steps. For respondent number?
5, 6, 7, and 10.
5, 6, 7, and 10. Next para. The MS Arbasar London State Council as well and Mr. Opada London Standing I mean special PP ACB as well as MS so and so. Granted 3 weeks time to file affidavit.
Obliged.
Item number 18.
For what? Steps for service of
73.
No steps. Why?
No, my lordship, step has been taken from the PP through registry. And
It
here
says, office note says no steps.
already step in the last order, it was awaited for respondent number 12.
No, this is order is 24/6/2026.
This is from, Your Honor, not from petitioner side, but from the
Who has to
registry,
take steps?
from the PP office.
Huh? You are not,
I'm from the petitioner for item number 17.
huh?
Petitioner for
In IA.
7.
IA?
17.
And check the ground. There is no explanation.
Adjourn कर लिया था.
You are not the applicant. Item 18,
Lordship, 17
So
was
sorry,
adjourned.
I'm from
It
the,
was taken-
17 already adjourned.
already adjourned.
but I,
17, record her name in 17.
Your Honor, I have some prayer for item number 17 because the
It is
accused
also
is,
been adjourned.
accused is inside the jail, so matter may be fixed for 29th of June.
No, there's a problem. Because the brief, the initial PP who has been entrusted
Yeah.
has
She
unfortunately.
didn't, like inform us, so. she
No,
didn't-
no. You discuss with your colleague, additional PP,
Okay, okay, much.
criminal appeal. Kindly discuss with, have a word with MS Tijini.
Okay,
There's an unfortunate, thing. Yes, item 18.
Item number 18.
18, my lord, we are for the respondents. IA is condemnation of delay for
No,
2
they are
days.
supposed to take step.
And correct, they have not taken any steps also.
Mitem Ratan. Ratan. Office note dated 24/06/2026 reflects that no steps has been taken for service of notice upon Respondent 5. Listen. Non appears for the applicant. Next, non appears for the applicant. Rest of next paragraph. Applicant, land constable applicant to take precedence for service of notice upon this within a week.
Item number 22 and 23.
Ready?
Otherwise, that is. Otherwise,
Yes, what do you say? Yes.
one is a challenge to the rule, another is the appeal.
This writ petition is what?
This is challenge to the rules. Item 23. 23 will have to be taken up first.
Okay.
Because, my lord, if the writ petition challenging the rules is allowed, then the other matter need not be heard.
Okay.
But only in the event the writ petition is dismissed. My lord, said.
But let us take up the writ petition 341 first. But this writ petition basically challenges words of 6.1 of the 2025 rules, my lord. Your lordship may kindly come to page 15. This is annexure 1, my lord. Your lordship may kindly come to page 17. That is the operative portion. 6.1. May I read?
Yes.
amendment of Rule 51B. In clause B of sub-rule 1 of Rule 5 of the APPS Amendment Rules 2025-3, for the existing entries, the following entries shall be substituted, namely, the remaining substantive vacancies shall be filled by promotion on the basis of merit cum seniority from amongst the officers who are substantively born on the cadre of inspectors of police, APP Civil, Inspector of Police APPBN, and Inspector of Police IRBN, employed in the state of Arunachal Pradesh in a manner prescribed in Part 5 of the rules. The post of Deputy SP, SDPO, Assistant Commander IRBN / APPBN, falling under promotional quota of APPS EG, shall be filled from amongst the eligible Inspectors of Police APPBN, Inspector of Police APPBN, Civil, and IRBN in accordance with the following ratio based on present sanctioned strength of post of inspectors in each unit. But this is based on the total strength of the post of inspectors. Now, 73.39 for the civil police, 15.35 for the IRBN, 5.26% for the APBN. The above ratio is based upon the present total strength of the three feeders as 228 posts of inspectors comprising 181 posts in civil police, 35 posts in IRBN, and 12 posts in APPBN. However, the ratio shall be reviewed after every 3 years based upon the sanctioned strength on 1st January of that year, and first review shall be on 1/1/2028 and so on. Now, my lord, the post of APPS entry grade is filled up by 50-50, 50% by direct recruit and 50% by promotion. Now, my lord, the total strength of the post is, the lordship may come to page 23. Start from. Now, my lord, in the table, serial number 54, 55, 56, 57, 58 pertains to IRBN. Now, my lord, we are inspectors of police and IRBN. Now, here the total post is 33. This is the total sanctioned strength of the entry grade, my lord. And out of this 33, if we calculate the 50%, roundabout comes to 17 posts is to be promoted from the IRBN quota. Now, my lord, here, if we implement this 6.1%, the total post for us, for the IRBN, comes to only 9%, nine posts. From 17 to 9 posts. 8 posts are made to die. Now, my lord, my basic submission is that the 33 posts, which is the sanctioned post, has not been changed. It remains, even in 2023 rules, even in 2025 rules, this sanction strength remains the same. So this is not proportionate. This clause 6.1 formulation is not proportionate to the sanction strength.
You are concerned about assistant commandant only?
Yes, madam. But all this DSP, SDPO, assistant commandant in IRBN and APPBN, they comes under the same category of madam.
It depends on where they are posted.
Yes, where they are posted.
Deputy SP, SDPO, and assistant command. Analogous.
No,
analogous post.
Yes.
Post or
interchangeable. I can, even if I am IRBN, I can be posted as DSP also. So likewise, I can be posted in APPBN and as SDPO. So these are the common cadre, my lord.
Okay.
Now, my lord, if we talk about the seniority, with that I will come later on. But then, my lord, we are senior than all those subsequently promoted inspectors in the cadre of inspector, my lord. Now, my lord, this fixation of percentile basis is totally arbitrary. It cuts into our quota. So this is not it is totally arbitrary,
Why are you
illegal.
saying that it's your quota? Why you are saying it's your quota?
Well, our quota is this 33%, 33 post constitute 36.56% of the total
This
post
was
of
this APPBN, IRBN and all.
yes
Civil.
civil. Well, you Lordship may kindly come to page 23 again.
Yes.
Down below here, the total post is 105.
Where do you get it? 23.
23, page 23.
105.
This is the total strength of the APPS entry grade, which includes
50%.
DSP, SDPO. So this includes both promotional and direct recruit quota, my lord. So
105 total.
105 total.
Then
so, my lord, I have worked out on top just some mark is there for civil. There is a 60 post. Now for APPBN it is 12. For the IRBN it is 33. On the right side I have just made a mark. My lord, these 60, 12 and 33 is the total post. Now 60 is marked for the civil police.
IRBN.
IRBN.
Okay.
Now 12 is for the APPBN. 33 is for the IRBN. So these
APPBN as well as IRBN. No, you are only APPBN. Only IRBN.
Only IRBN.
Okay. So 33 according to is 33 is for you.
For me.
Okay. Yes. Then
my lord, 12 is for the APPBN. APP battalion.
You are not concerned.
I am not concerned. 60 is for the civil police.
Okay.
Now, my lord, when we have joined the service and when we see this 33 strength post, now, my lord, we have also a legitimate expectation that we will be getting this share of promotional.
So by this amended rule,
yes,
how many posts are to be filled?
No, 15.36% comes to 9%, 9 posts only.
No, 0.5. 0.5. No, 0.5.26.
That is for battalion.
15.35.
That is for.
Okay, IRBN. You are IRBN, right?
Yes, IRBN.
Okay.
Page 17, my lord.
APBN. Yes.
Page 17.
Okay.
15.35% to 9 posts only.
Okay.
There is another aspect why they have come to 9 and why they have promoted only 8 so far. That also that is not part of these writ petitions, but just as a matter of reference, I will be explaining that also slightly, my lord. Now, my lord, what apart from this, my lord, I'll just take aside your lordship one thing.
Total post is by whom? This is by this is schedule. Okay.
This is by the rules, my lord.
Rules itself.
The rules itself provided that 105 are the total posts of APPS EG. Out of these, 60 are for the civil, 12 for the APP.
No, that was earlier. Now they have amended the rule.
No, my lord. But they have amended the rule, but they have not amended the
schedule.
Strength.
Okay. I mean, though they have amended the rule, but then
They have not touched the,
has not been amended.
they have not touched the sanctioned strength.
Yes. Okay.
So, my lord, my another submission is 33 posts are earmarked for the IRBN inspectors, and if we apply these rules, this percentile basis, the 33 posts shall never be substantively filled up. It will always remain within 8 or 9, as has been done today.
No, obviously, if the rule has been amended, then 15.35%, I think it will be it will come around 30 something.
9 posts only. Whereas the sanction for us sanction strength is 33. Out of that, 50% is 17.
So what's wrong in the amendment?
No, the wrong in this amendment is, the first thing is that it's our 33%, 33 posts, the reserve post, that means the 50% by direct recruitment, it will never be substantially filled up. Now, my lord, we are also in service. We also expect that one day we will get our share of promotions or service benefits. Now, my lord, therefore, these provisions creates legitimate expectations for us also.
So, in simple words, the post reserve for you have been taken away by this amendment.
Yes, my lord.
Making it the lesser.
Yes, my lord.
Although there was 33, now by this percentage of 15, it will come to 8 or 9 posts only.
Yes, my lord.
Only whether that can be taken away.
No, my lord, if we go into the, my lord, since this in broad, your lordship has got the point. Now, my lord, government during in this another connected read appeal, connected read petition, they have taken the category stand, and here also in this in their affidavit opposition, that there were some defects in the earlier rules. So therefore, these earlier rules were required to be modified. That what was those defects we could not really fathom with. We didn't know. But then during the pendency of this present writ petitions, we have come across certain documents which will show what were the defects and how this percentile basis came into being. Now, if I just take your lordship to my reply affidavit, in government affidavit, basically that is the sum and substance of their argument, that this is totally justifiable.
Certain defects were there to cure that they have amended
the rules.
Okay. So what is the defect they have not specified?
Yes.
So in the meantime, you have come across.
I have come across certain
those defects. So what is your?
My lord, page 95, annexure 4, my lord, in my reply affidavit.
90?
95. Right person is 96%, my lord.
95. Yes.
May I read, my lord? To such and such senior government advocate, Guwahati, such and such, subject WPC number 24, AP 24, such and such and such. Sir, in response to your letter, my lord, these writ petitions were also connected to the same category of officers only. In response to your letter number such and such and such, I am directed to inform you that as per clause 4 of sub-rule 1 of rule 5, Arunachal Pradesh Police Service entry grade post of sub-divisional police officer, deputy superintendent of police, assistant commandant, APPBN plus assistant commandant IRBN shall be filled by promotion from amongst the eligible officers belong to the respective feeder cadre grade post of inspectors of police, civil, APPBN, IRBN as specified under clause B of sub-rule 1 of rule 5 of clause A and B1 of sub-rule 1 of Rule 12 and 26. It is clear that the promotion to the post, to above mentioned post will be from the respective feeder grade cadre post. However, clause B1 of sub-rule 1 of Rule 12 and 26 as mentioned above were proposed from the Home Department, which were inadvertently omitted from the final draft. Now, this is the only defect. Final draft of Administrative Reforms Department, which makes the APPS Second Amendment Rules 2023 incomplete. Hence, the Home Department is revisiting the discrepancies found in the notification number such and such and such, and same shall be taken up with the Air Department for necessary modification. Till the APPS rules are appropriately modified by rectifying the discrepancies found therein, no DPC meeting would be conducted for considering promotion at any grade, my lord. Now, my lord,
these are internal communication.
yes, internal communication, but it shows what are the defects in the 2023 rules and what is intended to be rectified. And that is how this 2020.
It says that they had proposed certain thing that has been omitted.
Omitted.
Therefore, they
Now, my lord, my respectful submission is
revisited and
yes,
rectified.
Now they have proposed certain things which were not incorporated in the final draft. What are the defects? Defects is only about the inclusion of certain clause B1 of sub rule 1 of Rule 12 and 26. It it is only my lord, technical and drafting related omissions only.
It's all right. These are, I mean, the internal communication plus the view of whatever the officer concerned. It doesn't have nothing to do with the amendment. You come to the substance.
Yes, my lord.
Why this rule is bad? Number one, you have said that by this amendment, it takes the post, your post, away, which which is, I mean, by depriving or they violates the legitimate expectation.
No, my lord.
And as the schedule clearly specified a particular number of posts.
No, my lord. Not only that.
That's the only.
No, my lord.
And
this amendment procedure was carried out without following due process. There is a requirement of consulting with the Administrative Reforms Department as well as the Arunachal Pradesh Public Service Commission. In this case, they have bypassed the Arunachal Pradesh Public Service Commissions. That is one. Secondly, my lord.
Why you are saying so?
My lord,
where is the requirement?
Yes, I have the documents and then the patterns also. Now, my lord, the second thing is
there any other rule?
Yes.
For amendment of the rule, the Public Service Commission as well as the administrative, this department has to be consulted.
Yes, it is there.
What is that rule? Or it's a guideline?
Your Lordship may come to page 101. Page 101.
101 of affidavit.
Reply affidavit.
Reply. 101. Office memorandum.
Yes. Procedure for framing, public amendment, public relaxation of recruitment rules, service rules. The undersigned is directed to convey that the service rules and recruitment rules of all the post public service are framed under the proviso to Article 309 of the Constitution of India. They are subordinate legislations and statutory in nature. As per the laid down procedure, the service rules which are necessary to bring them in conformity with the changed provisions such as number of posts, educational qualification, pay in pay matrix level, residency period in the feeder post, etc. The state government, by office memorandum number such as has also issued the guidelines for framing of recruitment rules, oblique service rules. However, it has been noticed that despite issuing the clear repeated instructions, oblique reminders from the Department of Administrative Reforms, many departments, oblique officers are not updating the existing service rules, oblique recruitment rules, or even framing the recruitment rules for the newly created post-designations. The recruitment-promotions made by the department-office without updating the service rules or recruitment rules with the change in the conditions of service is viewed very seriously by the state government. 3. Consequent upon adoption of the Central Civil Services Revised Pay Rules 2016 and pursuant to implementation of the recommendation of the 7th Central Pay Commission, there was certain changes made in the service conditions of all the categories of posts. Therefore, procedures for framing of the recruitment rules, service rules issued by OM number such as is hereby modified and following procedures are prescribed for framing, amendment, relaxation of recruitment rules, service rules to all category of post services under the government of Arunachal Pradesh. 1. The department shall submit the proposal for framing of the recruitment rules, service rules, amendment, relaxation in the format along with required informations in the annexure appended with this office memorandum. A. Pro forma for submissions of proposed for framing of recruitment rules to the Department Administrative Reforms and APPSC or APSSB.
Yes.
A provides that it has to go to the Administrative Reforms Department and Arunachal Public Service Commission or APPSB. There are a category of posts which are recruited through APPSC and which are certain groups of posts are recruited through APPSB. So, my lord, here I have annexed the cabinet, the entire notes also. My lord, APPSC has not been consulted. My lord, there was instances where APPSC was consulted, but not in this case. Secondly, my lord, this percentile basis was never initiated by the Home Department, that is the parent department. My lord, I have
Yes.
It started with note number 274, my lord. Note 274.
Yes. Earlier amendment rules has been made. Not yet.
Now, one just example, my lord, where the proposal was consulted with Public Service Commission. May I take lordship to 103, my lord, Annexure 7.
And I borrowed the copy or not second.
My lord, this was pertaining to the 2003 amendment, my lord.
Yeah.
I am directed to forward here with a copy. My lord, this is addressed to the Secretary, Arunachal Pradesh Public Service Commission, Itanagar. I am directed to forward here with a copy of the Police such as Amendment 2022, which was duly vetted by the Air Department. In this context, it is requested you to examine the draft said rules and furnish your views, comments for finalize the said rules, my lord. This is an example where Public Service Commission was consulted. But in this case, no consultation, my lord. Well, I have annexed the entire relevant file notes.
Showing that it has not been consulted.
No, my lord. Nothing, my lord.
Okay. That's all.
No, my lord. Another aspect is, my lord.
First is taking over the post.
Yes. So this is second. The third is, my lord,
Third is no consultation with public service.
No public.
And third?
And my lord, this proposal of percentile basis was never initiated from the home department, the parent department.
This percentile basis? You're not initiated.
No.
Not initiated.
No, it was not initiated by the home department. It came up through note number 396, my lord. My lord, at page 143. My lord, I have annexed those note sheets, the relevant note sheets from page number 104. Now coming to 143, my lord, after 42 pages.
Has given their observation so they gave the following views.
The Administrative Reform Department has given their observation at such and such, where they have gave the following views on the instant proposal such and such. My lord, in point number 3, this was for the first time this formulation began.
So it was initiated by administrative?
Only in my administrative reforms department, not by the parent department, home department.
This was the views of the administrative department?
Yes.
So they have accepted it?
They have accepted it.
It may not be necessarily mooted initially, but then once they've consulted
therefore, my lord,
reform, they have
now
suggested and they've given a view that has been accepted.
my lord,
what's wrong with that?
Therefore, my lord, we have to look back into the nexus with the objective of the amendment. The objective of the amendment was to rectify drafting mistakes. Was only a drafting mistakes, omission, drafting omission. I should say drafting omissions. Now that is the nexus of this amendment.
Therefore,
now
you are trying to, you are suggesting, you are saying that the amendment has been made mala fide.
I cannot say mala fide, but then, my lord, this did not have the nexus with the objective of the proposed amendment, which was initiated. That initiation was subject to a drafting omission. Now, in the guise of rectifying a drafting omission, they have introduced a totally different methodology, my lord, which is detrimental to us, which is detrimental to not only to us, it is detrimental to the APBBN and giving extra mileage to the other branch, my lord. My lord, government can always amend rules. They can take actions for the betterment of one group of officers, but then that power should not be at the cost of my rights, my constitutional rights, my lord.
Yes. Out of 33 posts, suppose if we go by the amended rule, where the other post will go? 15% if you say.
It has gone to the civil.
It will go to the civil.
Civil. Now, my lord, as per this strength, civil police has the strength of the sanction strength of 56%, 56 point some percent. We have about 36. Then APBBN has about 12 or 14%. Accordingly, that is the sanction strength as per the recommend rules, my lord. Now, my lord, not only about the requirement to consult with public service commissions, may just
We'll come back after 5 minutes.
now, my lord, to sum up my submissions, my lord,
That's why we have taken a break, so that you can sum up.
so my lord, this feeder cadre strength.
Yes.
This formulation has introduced this. Now, this has totally cut down the what it is our right under the sanction total strength. So now, as I've submitted, they have now promoted 42 inspectors. We are not challenging their promotions. That will be automatic subject to the outcome of these petitions. But then, just for the purpose of reference, what they did is they have taken the entire post.
43 inspector of to assistant command. I mean this thing.
To this EG group, APPS entry grade. There 34 were from the district and only 4 were given to us. And that is IRBN. They have said you are entitled for only 8. We are saying we are entitled for 9, even if this formula is applied. And this 8 has been adjusted with those 4 persons which has already been promoted under different rules, earlier rules. Now 8 has been counted, only 8 has been given, and 8 has been.
So that is deputy SP.
Yes, deputy SP. This and let us say entry grade, because in entry grade there are 3-4 categories of officers.
Okay.
Now they are also.
So this post, according to this, they have taken away this post reserved for. I mean, quota for you has been taken away by this amendment, and
Given to-
it has been filled up by
civil police.
direct recruit or entry
No,
grade.
no, my lord. Whether it is direct recruit or not, because this is cumulative post number will be there, and out of that cumulative number, 50% will be for the promotion. So whichever percentile comes within that 50% of promotion, it will be given to the civil police only.
Okay.
Direct recruitment is different totally, my lord.
Okay. It's for so far as
Yes,
we're concerned about the promotion. Only.
Yes. My lord, what I'm submitting is not exactly related to this within the this realm of this writ petitions.
Then don't make a submission.
Otherwise, my lord, it is slightly relevant also. Relevant in the sense.
Either it's relevant or it's not relevant. It's not. It's slightly.
It is relevant, but it is not within the realm of this writ petitions. Now, anyway, my lord. Now, my lord, the entire process, as I have submitted, my lord, government servant, he has certain dream and expectations, my lord, within the prescribed rules, of course, my lord.
Okay.
Now, my lord, violation of those expectations is also in violation of Article 14 and 16.
Yes. Which board is state? We'll hear the state person. Or
I can submit.
okay.
I have
This judgment or what?
no, only just
Written submission.
Written submissions.
For this writ petition.
Yes, for the writ petition.
Speak.
With greatest respect, my lord, the only ground on which this rule has been put to challenge the virus is on the premise that the 33 posts of assistant commandant, out of which 50% has to be filled up, that is 17 posts, by way of promotion, is reserved for IRBN.
Okay.
That is the only way somebody can take it away. That is the only ground. Their grounds are set forth at paragraph 4, 5 and 7.
You are for private respondent.
Private respondent.
5 to 11.
16.
16, okay.
Now, from the rules, at page 23, your Lordship comes back again. Total is 105 posts. But I will kindly note, this post is Arunachal Pradesh Police Service entry grade. Common cadre, nothing else. Out of this, your Lordship will see at page 23, the 33 they have calculated, they are saying 17 is only reserved for the inspectors of IRB. That is the only way that other for now, because of the percentile, they are given only 9 posts, 8 posts. So thereby taking away 11 posts. That was reserved for IRB. That is their case. The greatest respect, Madam, that is only misconceived. From the very beginning of the department, Arunachal Pradesh Police Service entry grade has been a common category. Filled up from the grade of inspectors, civil police, APPBN, and IRB. That is all along how it has been filled up. Now, no rules have been annexed to the requisitions, the earlier rules. If your Lordship kindly have my affidavit 5 to 16. At no point of time, only when the 2023 rules was in force for around 1.5 years, I will show that. Well, I will take your Lordship to some of the rules so that, my Lord, this will be relevant even the read appeal, so that I don't have to repeat it again. Your Lordship will kindly mark at paragraph 4, 5, 6, and 7. That is their ground.
Page?
In the requisition, the page 5. Paragraph 4, 5, 6, and 7. That is the only ground. That 33 out of which 17 has to be filled up from the cadre of Inspector IRB. Because of the percentile, the post has been taken away. That is their only case. Now, your Lordship have my affidavit at page 285. Bitte. Komm. Haben die noch beide kennen weiter? Aber ne. Ich glaube nicht. Here.
Yes. 285.
Serial number 3. Then your Lordship will come to page 286. Method of recruitment, serial number 5. 5B. Remaining such substantive vacancies shall be filled by merit cum seniority basis with due regard to seniority in the manner specified in part 5 of these rules from among the officers who are substantively born in the cadre of Inspector of Police in the state of Arunachal Pradesh. Your Lordship will 3B, you will find the name of the post, that is Deputy Superintendent of Police / Assistant Commandant Armed Battalion. IRBN was not there at that point of time. So, from the cadre of inspectors, it is not that from AAPB it will go to Assistant Commandant, and from the civil police it will go only to DSP and SDP. It was not that. On the basis of seniority come merit, they will go there. If they need entry grade, they can be posted anywhere, either as Assistant Commandant or as DSP, SDP.
So civil police can be promoted to
entry grade only. This is a common cadre.
Entry grade.
Yes, they can be posted as Assistant Commandant.
And then when it comes to this thing posting,
yes,
then the nomenclature or the name of the post is
from APB at that point of time, the early first rules, they are promoted to entry. They can be promoted, posted as DSP also.
Okay. Okay.
Common cadre.
Yes.
This rules standard was amended in 2006 at page 293.
Yes.
Amendment to Rule 3, your Lordship have column B, APPS entry grade, under bracket, Deputy Superintendent of Police / Assistant Commandant. Common cadre. Entry grade. That's the name of the cadre.
Entry grade.
Yes. Includes the post of Deputy Superintendent of Police at that point of time, as well as Assistant Commander.
Hmm.
Then your Lordship will see at page 295 how it is we filled up. Serial number 6, amendment to Rule 12.
Hmm.
Right.
Yes.
The Departmental Promotion Committee shall consider from time to time the cases of officers eligible under sub-clause 4 or clause B of Rule 5 who have served in the cadre of police, including, kindly note, Arunachal Pradesh Police Civil, Arunachal Pradesh Armed Battalion, and Indian Reserve Battalion, etc., for not less than 5 years, and prepare a list of officers recommended taking into account the actual vacancy at the time of selection and those likely to occur in a year. The selection shall be made on the basis of merit cum seniority. From amongst all these 3 wings, they will go to APPS entry grade. Now, my lord, this was changed for a small amount of time in the year 2023, 308. There, my lord, it was provided to Lordship at 309. 4, serial number 4, sub-rule 4.
2023.
23, yes. From 89, it was always been a common cadre. In 2023, why this route was changed, I am coming to that also.
Yes.
For the first time, from AAPBN to Assistant Commandant AAPBN from their own cadre. Civil police to their own cadre. Serial number 4. Arunachal Pradesh Police Service entry grade, post of Sub-Regional Police Officer, Deputy Superintendent of Police, Assistant Commandant, Assistant Commandant IRPN shall be filled by promotion from amongst the eligible officers belonging to the respective feeder cadres. So this was only for the first time when this was brought in. This was in 2023. There is the IRBN inspectors will be Assistant Commandant IRBN. AAPBN inspectors will be Assistant Commandant AAPBN. And the civil police inspectors will be promoted to DSPs, SDPOs, like this.
Yes.
Now, page 313, Lordship will find the communication. The government was not happy with these rules.
2023.
Yes. This always because the entry grade has always been a common cadre. Because of heartburning among the civil police, this was changed at that point of time. But ultimately, they thought, no, it will have to be a common cadre. There will have to be a new rule incorporating the present police. Now, why, my lord, there was heartburning in the civil police? Your Lordship will see that at page 314. This was just before the last promotions. Your Lordship will see at the left-hand side names of the inspectors of civil police. Your Lordship will see their date of initial appointment. I'm just giving an example. Deepak Lankam, first one, is a respondent here. He was appointed as sub-inspector in 1989. Your Lordship will come to the right side, middle part. I have been inspector. The first one is Dorson. Lordship will see when he was appointed. 2006.
Which one?
Dorson. Date of initial appointment, IRB.
Serial number?
1. In the middle section, manner. In the left-hand side, you will see civil inspectors. Middle one, IRB inspectors. I am just showing why this had to be changed. Deepak Lankam appointment was as sub-inspector was 17 to 1989. His promotion to inspector was 14/8/2013. Doors announced initial appointment sub-inspector was 17 years after Deepak Lankam. Sub-inspector. He was promoted to inspector on 25/7/2012. Earlier to Deepak Blanca. Why this has happened, my lord, I have explained in paragraph 7 of my affidavit. The cadre strength, I have given everything. I will just point out, it is there in paragraph 7. Sub-inspectors, my lord, there are 400 sub-inspectors in civil police.
400.
Yes. I have been 115 on. So that is how the expectancy has come, and your lordship will find that is the reason the AR department has given at note 396, 94. I will just point out in the note that my learned was showing, but administrative report. That is the reasons they have given. There has been disproportionate promotions. Juniors have been earlier promoted, and in fact, 4 IRBN inspectors initially appointed the sub-inspectors. In 2002, they have already been promoted much earlier to the cadre of efficient activity. I will show that also. So that is why there was a requirement for changing the rules.
So accordingly, it's a case, kind of rationalization.
Yes. Yes.
Based on the number of posts of the inspectors in the respective, I mean.
Because in the grade of APCS entry grade, it forms a common cadre. 2002 appointment as sub-inspectors are entry grade officers above me. I'm going 89, 90, 91. You also see the list. That is why the requirement. And you also will see all these inspectors 1990, 1990 up to number 7.
So entry grade is for this the sub-inspector.
So
in a lower grade. Lower grade, it's a sub-inspector or what?
No, first a sub-inspector, then inspector, then entry grade.
Okay. No. Initial entry of the post.
Sub-inspector.
Sub-inspector.
Yes.
It cannot be not from constable. Can it be from?
They come from there also.
Okay.
All these people were initially appointed as sub-inspector.
Normally it may not, but then it can come also.
They can come.
From constable to entry grade.
Up to ASI.
Okay.
So your lordship sees 1989, 90 officers. Somebody like Akanta, he just got promotion around 4 or 5 months back. I think he's going to retire now.
So this constable inspectors, sub-inspector and inspectors, they have a different, they are different cadre.
Yes, as far as the inspectors are concerned, sub-inspectors are concerned.
Okay.
From sub-inspector, APBN, they will go to inspector APBN.
Okay.
I mean, that is affidavit also.
Okay.
That is all there in there. From IRBN to inspector IRBN.
Okay. Not the civil, not civil. So they form a different, I mean, different cadre.
Different cadre so far as sub-inspectors and inspectors are concerned.
Okay.
That is how they are stealing a march.
Okay.
That is why there was this requirement. So the list is given here. I'm not bothering on lordship. Lordship sees the dates. All these petitioners are 2006 batches as sub-inspector. Your lordship will kindly at page 318.
So this, your 314 is a ratio-based distribution of vacant post. This is only for vacant post.
Yes, that is for the purpose of showing, my lord.
At that point of time.
Yes.
35 posts.
These were the persons who are, my lord, under the zone of consideration in terms of the latest rules.
Okay.
They have been promoted also.
Okay.
Some of, not all. So your lordship sees here the 2006 sub-inspectors. They are promoted earlier to the grade of inspectors. So they will obviously be promoted for the sub-inspectors who joined initially as sub-inspectors 17 years earlier than this person.
Okay.
My lord, kindly know Deepak Langam is 89. I'm just showing another list at page 318.
Okay, we have understood.
That's for the purpose of showing. 2001, the first 4 serial numbers. They were appointed in 2001 as sub-inspectors. 12 years later than me, they were promoted. They have already been promoted to the post of APCS entry. So that is how, my lord, the present rule at page 320 came into force. Based on the cadre strength in the grade, in the feeder grades. That is how the percentage has been worked out.
Okay.
So I'm repeating again, the only ground they're urging is 33 post of
Assistant Commandant.
Assistant Commandant is reserved for higher grade.
Hmm.
That is wholly misconceived.
Hmm.
It has always been a common cadre except for 2023. When 23 rules was enforced and was thereafter it was also changed on 7th of April 2025.
Hmm.
That was the only period, around 1.5 years.
Hmm.
So that contention, my lord, is wholly misconceived. Apart from that,
But by 23, it appears to be by 23 rules.
yes,
It
They
has
tried
been,
that, they
it has been, reserved for IRBN only
yes, yes,
by 23.
23 rules.
Hmm.
All of them, my lord, they were given,
Hmm.
but it has been a political decision all along.
Hmm.
From the very beginning that it will form a common cadre.
Hmm.
The government in their wisdom thought we will have to have a common cadre.
Hmm.
What is wrong with that?
Hmm.
That is what the petitioner will have to show the court. In the greatest respect, nothing has been said, except for saying that our post has been taken away. So all this,
In that case, it's correct. By 23 rule, these posts are given to the IRBN only. 33 posts
yes,
by 23 rules.
23.
Because by 23 rule, only the inspector of IRBN can be promoted to these posts,
Yes.
assistant commandant.
That is there.
Right.
That is there. What I am saying is,
Ah,
all along that has been,
it's okay. That I've understood. So in that case, while challenging this, they may be correct.
yes, yes, they may,
That's by,
they may be correct.
yes.
Yes, but is the government precluded from
Hmm.
framing a rules?
That is another aspect. Yes, that is the issue. That
Yes,
may be.
that
But
is the issue.
claiming as such
Yes.
on the basis of Rule 23 is not. I mean,
Yes.
it
So
appears
that is
correct.
why I'm submitting, madam.
Yes.
As long as the petitioner does not make out a case
Hmm.
as to how, madam, this is ultra-virus to the Article 14 and all.
Yes.
There's no question of, madam, interference by the law.
Okay, that is
That is
something. Yes, yes. That I've
There is
understood.
always a presumption to the validity of the rules. I would like to, madam, cite a few judgments, madam.
Okay. Give at best 3. How many judgments?
Yeah, I will give 3.
Just give 3. The latest and nearest.
Uh,
If it covers the issue.
yes, yes. This is by revision bench of our own High Court.
Just give this thing.
Citation is 2014 3 GLT 564.
2015 3 GLT
564.
564.
I brought it because it has been authored by Honorable Justice Ansari. He is always very, very elaborate on things, that's why.
Okay. Para?
Paragraph 15 to my lord. 23, 26. Yes.
Then next.
May I read a few paragraphs? I will not read all of them.
Hmm.
Few paragraphs. Paragraph 15, madam.
Hmm.
As a policy decision, when the government for functional, operational, or administrative improvement makes any change in the service condition of its employees, the change so introduced cannot be interfered with unless the change is found unconstitutional. I don't know these are all settled laws. The constitutional, unconstitutional will obviously include a policy. We need at this stage to remind ourselves that though the employment of a government employee and the employment of a person in the private sector is originally contractual in nature, what distinguishes the government employee from others is the government employee requires his appointment to the government officer status. As a result of this, requires a service conditions are determined on the basis of the relevant provisions of the Constitution and the statute. In consequence thereof, a government servant's rights and obligations can be determined by the statutory or constitutional authority concerned, and for such exercise of powers, the statutory authority concerned does not, unlike the case of private employee, require consent from the government employee concerned. In other words, the government can alter terms and conditions of its employees unilaterally, though in practice such alteration may face protest from the employees concerned. This does not, however, mean we must hasten to act. The consent of the government employee is a condition precedent for changing the terms and conditions of service by the statutory or constitutional authority in terms of the provisions of the relevant statutes and or the Constitution. A reference may be made to the case of such and such. It is well settled that though employment under government under any other master may have a contractual origin. The government servant acquires a status on appointment to its office as a result. Its rights and obligations are liable to be determined under statutory or constitutional authority, which for exercise requires no reciprocal consent. The government can alter the terms and conditions of its employees unilaterally, and though in modern times concessions in matters relating to public service is often attempted to achieve, the consent is not a precondition of the validity of rules of service. The contractual origin of the service notwithstanding. But services from the above means that the service conditions of a government employee can be changed by making changes in the relevant statutes or rules by the statutory or constitutional authority concerned in terms of the statute and or the constitution. My lord, this goes on in this manner. Paragraph 23. Dealing with the concept as to when a valid piece of legislation can be struck down. The Supreme
It's
Court-
okay. It's okay.
That's it.
Next.
Next is 2003 to SCC 632. Paragraph
2003
2 SCC
to SCC.
632.
Yes.
Paragraph 8 to 10. I am reading only 10. We have carefully considered the submissions made on behalf of both the parties. Questions relating to constitution, pattern, nomenclature of post, cadres, categories, their creation, abolition, prescription of qualifications and other conditions of service, including avenues of promotions, and a criteria to be fulfilled for such promotions pertaining to the field of policy is within the exclusive discretion of the jurisdiction of the state. Subject, of course, to the limitations or restrictions envisaged by the Constitution of India, and it is not for the state tribunals anyway to direct the government to a particular method of recruitment or eligibility criteria or avenues of promotion or impose itself by substituting its views for that of the state. Similarly, it is well open and within the competency of the state to change the rules relating to a service and alter or amend and vary by addition, subtraction, the qualification, eligibility criteria, and other conditions of service, including avenues of promotion from time to time and established exigencies may need or necessity. Likewise, the state by the appropriate rules is entitled to amalgamate departments or bifurcate departments into more and constitute different categories of posts or cadres by undertaking further classification, bifurcation, or amalgamation, as well as reconstitute and restructure the pattern and cadres categories of service as may be required from time to time by abolishing existing cadres posts and creating new cadre posts. There is no right in any employee of the state to claim that rules governing conditions of his service should be forever same as the one when he enters service for all purposes, except for ensuring or safeguarding rights or benefits already earned, acquired or accrued at a particular point of time. The government servant has no right to challenge the authority of the state to amend, alter, or bring into force new rules relating to even an existing service.
Yes.
All other rules, judgments of a similar line.
That's all.
That should be enough. And one thing I want to point out, this office memorandums that has been relied upon, these are at best advisories. This is not even issued in the name of the government. And to that effect, these submissions were not in the petition. In any case, communication between a deputy secretary and a senior government advocate cannot be taken into account. And this office memorandum which has been relied upon is not issued in the name of the government. On that matter, I will not read the just submit one judgment. 2014 10 SC 6673. Paragraph 20 and 21.
2014.
2014 10 SCC 673.
673.
Yes. Paragraph 20 and 21. Clause 2 of Article 77 also provides for authentication of orders and instruments in the manner as prescribed by rules. In this regard, by such and such publishing there is a such issued authentication orders, the said rules have been super subsequently admitted provisions and such and such. 21. In the absence of due authentication and promulgation of the guidelines, the contents thereof cannot be treated as an order of the government would really represent an expression of opinion. In law, the said guidelines and their binding effect would be no more than what is expressed by this court in the case of such and such. In the following paragraph of the report, it is well settled that all executive actions of the government and the government of the state are required to be taken in the name of the president or the governor of the state concerned, as the case may be. Orders and other instruments made and executed in the name of the president or governor as the case may be are required to be executed in the manner specified in the rules made by the. In other words, unless an order is expressed in the name of the president or the governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. Remember, this is at best an advice. And the reason, my lord, the percentile has been, my lord, worked out. The lordship will find that in the reply filed by the petitioner had note 397. That is the note item. And my lord, kindly note in paragraph 7.
Yes.
I have stated, my lord, the cadre of cadre staff of inspector.
What is that note?
At page 143 of the reply. Not 397.
Where the administrative reform has given given their view.
Yes.
Okay.
And my lord, in paragraph 7 of my affidavit,
yes, that
I have wrongly quoted 288 inspector. It should be 228.
228.
Yes. That's all, my lord. The petitioner, except for submitting, then the post has been taken away. Has not, my lord, shown. That was, my lord, they cannot have any vested right for that. The government can always alter the service condition. And I have shown why they have to do it. So in the absence of anything, my lord, to show the unconstituted rules, there's always a presumption in favor of the rules.
Okay.
This is my answer.
Yes.
Since very limited. My lord has seen the hierarchy. It is will be concerned from sub-inspector to inspector and the entry grade. Entry grade will include DSP, SDPO and command. Now, although from 1989 there it was always a common grade. In 2000 up to 2006 also. Only in 2023 amendment there was an attempt to make it distinguished from respective cadres. The common cadre was to be good.
But
there are certain ratios.
But nobody, but you yourself only.
Yes, yes. Now that was something which was not implemented.
Okay.
Then
not implemented.
Yes, that was not never implemented. My lord will kindly
yes
have the background also some. Here, sub-inspector of police, the civil police, IRB and APP there, although they had different recruitment rules, but they used to be recruited by a common recruitment process. And those in the top merit list, top of the merit list, they used to prefer the civil police because the number of posts was higher, larger. Then accordingly the IRBS and then APP. Now in the merit list, although those civil police were in the merit list above the IRBN and APPBN, they never used to get the promotion, and the IRBN, they used to have a march despite being in the lower ranking in the lower in the merit list. They used to have a march about the civil police, and by this, those who have opted for civil police, they used to be different. This is there. My lord, I'll show the minutes of the meeting. How this at page 54 of our affidavit. Because this has caused heartburning. Despite being ranking top in the merit list, those who ranked below and opted for IRBN, they used to have march over the meritorious persons.
That is not it's not a problem of those people.
No, it's not because of.
This is luck for these people who have been, selected below.
Yes.
And unlucky for the civil police.
Yes, that was heartburning, my lord. That is the main reason, my lord. Page 54.
Heartburning will, of course, we understand, but then.
In fact, it has, therefore, the government has.
Is it not like you are stretching someone's luck?
We are trying to balance everyone's luck, everyone's opportunity.
They say that why the boys always have a fun.
Yeah. My lord will kindly.
So they are in merit list, top of them. And then when the luck favors the person who is below,
yes.
All right, everybody wants to be on top. Nobody wants to be at below.
Yes.
So when the luck has struck to them, you want to snatch them from them.
They would,
luck is luck, don't snatch.
They try to enjoy this stuff.
Okay.
Well, can you see page 54? This is
54 of
our affidavit.
Affidavit, yes.
A lot of 8.1. As regards to recruitment of SI, sub-inspector. Though similar, there is separate recruitment rules for the post of sub-inspectors in civil police, IRBN, and APPBN. In the past, recruitment of SI level were done through common competitive examination. Those who were in the higher merit list were appointed in civil police, and those who were in lower merit list were appointed in the IRBN as per the availability of vacancies. However, due to vacancies of inspectors in IRBN, SI in lower merit list got promoted to inspectors, and even superseding many inspectors in the civil police who were recruited much earlier. And then by virtue of the provisions in the RR of FPPS, these inspectors in the IRBN were eligible for FPPS entry grade much earlier and ahead of inspectors in civil police.
What is this?
This is the minutes for amending the recruitment rule.
Okay.
It's one of many reasons have been for.
Okay. So we understood essentially.
Yes.
To
not burden.
rationalize or to prevent heartburning.
Yes.
Okay.
Now this is now Manor has seen the recruitment rule. In the recruitment rule, which is under tenants at page 70 of the writ petition. It says amendment of rule 5.1. The reason and then the percentile has been ratio has been given 79, 15, 5. All these have been given. In below this, the reason also has been quoted. The above ratio at page 17, if my lord.
Yes. Page 17.
The above ratio is based upon the present total strength of 3 feeders as 228 posts of inspectors comprising 181 posts of civil police, 31 posts in IRBN and 12 posts in FPPBN. However, the ratio shall be reviewed after every 3 years based upon the sanction strength on 1st January of that year, and such review shall be on 1/1/2028 and so on. Because of the existing sanction strength, out of 228, those who are in the line of promotion, 181 posts are there for civil police, from civil police, 35 posts in IRBM, and 12 posts in FBP. So this percentage has been. Now, my lord, the legal question whether the recruitment rule can be challenged. My lord knows, my lord, until and unless it is unconstitutional, ultra virus the constitution, and even if there is heart burning amongst the one set of the employees, even then the court may not strike it down. My lord, I have just two in the citing section, my lord. I'll only
Just give the citation and
2008 9 SCC 242.
242.
Paragraph I'll read, madam.
Para?
Paragraph 37.
37.
Paragraph 37. madam. May I read, madam? Before parting with the aspect of the case, we consider it necessary to reiterate the settled legal position that matters relating to creation and evolution of force, formation and restructuring of cadres, prescribing the source, mode of recruitment and qualifications, criteria of selection, evaluation of service records of employees fall within the exclusive domain of the employer. What steps should be taken for improving efficiency of the administration is also to preserve the employer, The power of judicial review can be exercised in such matters only if it's shown that the action of the employer is contrary to any constitutional or statutory provision, or is patently arbitrary, or is vitiated due to malafide. The court cannot sit in appeal over the judgment of the employer and ordain that a particular post be filled up by so and so, so and so. I look the last three. I'll read the last three sentences. The court cannot suggest the manner in which the employer to structure or restructure the cadre for the purpose of improving efficiency of administration. While then another is also only one paragraph. I'll read. 2007 13 SCC 320. Paragraph 41.
320.
320.
Same line.
Same line, but here.
Para 40?
41. Here, with regard to hard burning, it is no doubt true that service rules, however meticulously framed, there is always a chance of some hardship being caused to a particular section of the employees, but as long as the rules are just, fair and reasonable, and if two views are possible, the may some hardship, inconvenience or injustice results to some members of the service is not a ground to strike down the rule. It is not safe to test the constitutionality of a service rule on the touchstone of fortunes of an individual, if the rule otherwise appears to be fair, just and reasonable, and does not suffer from the vice of Articles 14 and 16 of the Constitution or any constitutional branch. The mere fact that some little hardship or injustice is caused to someone is no ground to strike down the rule. So
we can rely this also.
Yes.
You said.
Hard one cannot be only one-sided.
Yes.
It cannot be struck down.
It cannot be struck down, but then the manner the reason for amendment.
All has been rationalized, my lord.
So he's claiming under rule amended, then rule 23. So it may goes in favor of him also.
Yes, my lord, but
that's why I always try to prevent you to read this.
No, this is in my because now
anyway, I'm not later.
rule is the 2025 amendment.
Ultimately, we cannot interfere, that's all.
Well, and 2023 rules, that was never implemented. The very rule which they are.
That is the wrong submission.
It's okay, we'll not go into
No,
it.
just one-
Why they were just,
It's more qualified.
whereas of the 25 is
Yes.
under determination, so we'll not
Just
go
a
into
few
all those
clarifications, Malat. Malat, as far as submissions made by my younger brother Pangeng about this Annexure 6101, that office memorandum, Malat, I respectfully submit that yes, it is no doubt that under Article 166 of the Constitution of India, any policy has to be in the name of governor. But then those policies are citizen related. Now, Malat, if we see this 101, this is only an administrative within the administration. It's just to regulate how to carry out anything within the administrative help only.
will ultimately affect the citizen only.
Yes. So, and since I have relied upon 1A, but in 110 and 111 also may kindly be looked into. Then, my lord, as far as Hardban is concerned, my lord, as I have submitted, my lord, the Hardban cannot be one-sided, because let us see one thing. Now, my London younger friend has taken us to that sub-inspector. My lord, that is totally a different cadre. You have entered in the right or wrong service. I have entered in the right or wrong service, and that some rights facilities has accrued. For that, one cannot have a heartburn.
It's your fortune.
Yes, it's my fortune.
Misfortune.
Yes, Malad. Therefore, Malad, now imagine, Malad. Now the number of years he has spent as sub-inspector, if it is to be compensated this way. Now these persons who are much junior to us has been promoted now. All are junior in inspector. Now they will be occupying this post for so many years. What about us? We will get only eight posts, whereas we are supposed to get 19. Won't there be heartburn for us also?
That is your misfortune.
Yes. Then, but if it is both sides, therefore,
it's sweet.
Their fortune.
Yeah.
Now they misfortune.
now for that we cannot be made to suffer, Malad. Now, Malad, my response of submissions to my learned additional advocate general is that he has taken us to many issues, but I fail to understand that he has not explained the legally sustainable basis on which these decisions was arrived at.
That the minutes they have read, they have relied. Page 50,
That also, Malad,
54.
that Malad, this minutes is only a meeting. But then, Malad,
We're not saying this may be correct or not correct. And it's
yes.
justifiable or not.
My explanation to his submission is
Yes.
that these minutes of the meeting is only a sitting of only 7 members of the police department. You know, may kindly going through the composition of the members. Now, of the civil police, that's also only civil police. Now, there is no empirical study, no cadre review. It is only an opinion. Where is the cadre review? If there was a cadre review, and because of this cadre review, because of this empirical basis studies, if this has been proposed, it should have been reflected in the proper way. It's not just by an opinion. Number one, I just like to learn one judgment. 2008 5 SCC, page 416. 2008 5 SCC 416. I'll short paragraphs. I will rely only on 3 paragraphs: 28, 30, and 34.
28, 30, and 34.
34. May I read, Madam? 28.
Purushottam.
Page, paragraph 28, Madam.
Yes.
The superior courts, while exercising their power of judicial review, must determine the issue having regard to the effect of the substance the subordinate legislation in question, there must exist a rational nexus between the impugned legislation and the object of promotion. Promotions are granted to higher posts to avoid stagnation, as also frustration amongst the employees. This court, in a large number of decisions, has emphasized the necessity of providing for promotional avenues. The state, keeping in view that object, having found itself unable to provide such promotional avenues, provided for a scheme of accelerated career progress. The validity and effect of the impugned legislation must be judged keeping in view the object and purport thereof. This court would apply such principle of interpretation of statute which would enable it to subserve the object in place of subverting the same, my lord. But as I've submitted, my lord, the purpose of bringing this 2025 was
23.
Drafting omission, my lord. Then 2030, my lord. Although mere chance of promotion is not a fundamental right, but right to be considered, therefore, is, in that view of the matter, any policy whereby all promotional avenues to be promoted in respect of a category of employees for all times to come cannot be nullified, and the same would be hit by Article 16 of the Constitution of India. Let us come to paragraph 34.
Not relevant.
A statutory rule, it is tried law, must be made in consonance with the constitutional scheme. A rule must not be arbitrary. It must be reasonable, be it substantive or a subordinate legislation. The legislature, it is presumed, would be a rational one. And indisputably, the subordinate legislation may reflect the experience of the rule maker, but the same must be capable of being taken to a logical conclusion, my lord. My lord, therefore, my lord, this 2025 clause 6 is totally arbitrary and illegal, my lord. All right, lordship.
This judgment is for provision whether there is no avenue for promotion.
In respect of subordinate legislation. Okay.
Here there is a accepted voter in terms of the career history.
Are you appearing, President?
I'm appearing in the appeal, my lord. The aggrieved persons filed a writ petition saying that so far as they are concerned, the rules which have been subsequently amended do affect them, yes. But then for them, the process of promotion had already begun before the rules were amended. The process has already begun. There are judgments to show that if the process has begun, unless the rules which are amended given retrospective effect.
What is the view of the learned single judge?
My lord. Yes, my lord. In the appeal at page 23 is the judgment of the Honorable Single Judge, my lord.
Get the printed copy from library. This one you put it here. These appellates are
the same petitioners who have challenged the rules.
Okay, same petition.
My lord. My lord, in fact, my lord, as I submitted in the beginning, if they fail in their first writ petition, where they change the rules, then there will be need to address this issue. Because if they succeed in the petition, then this appeal will automatically stand allowed, man.
If they don't succeed,
then there is a requirement of hearing this and deciding this matter. It is subject to the outcome of that.
Then we will not hear it today. We'll decide this for the writ petition first.
Once that is dismissed, then of course there will be need to hear this. That is correct.
So according to you, basically, essentially, you are saying that even if rule is
yes, my lord, held to be valid,
then
the process has admittedly
the process has started before coming into the
exactly
coming into force of the amended rule.
Yes,
could not have applied the.
Yes, that is the contention. My lord, only one more legal submission. In the judgment, my lord, the Honorable Single Justice relied on the subsequent judgment whereby the Rangayesh judgment of 1983 has been overruled. Rangayesh judgment said vacancies falling prior to the amendment should be filled up according to the unamended rules. That was overruled, saying that no, the day on which the consideration takes place, whatever rule is existing, that will be applied, even if the vacancies arose prior to the amendment of the rules. But my case is not that, that reliance has been placed on that judgment to dismiss my petition. My case was that process was admittedly started, and they have deliberately delayed for pretty long time to see that in the meantime amendment comes. Why did you sit about the matter? You should have completed. And my lord, the process having been started admittedly, there was no question of applying the new rules. So subsequently you applied the new rules.
Okay, we'll hear
That, my lord.
depends on after disposal. We'll say so, we'll record that.
My lord. Lordship may record that.
Listed after disposal of the.
Yes, that has to be mentioned, madam.
Heard Mr. D. Majumdar, learned senior counsel. Or can we hear it and dispose it together?
It will be better if your lordship.
It is better once because some bearing may have on what observation your lordships make in this case, madam.
Assisted by? Who is that? Mr.
D. Majumdar.
No, D. You are also D.
Yes.
D. Majumdar, learned counsel for the appellants. And also had Mr. You are one. And Ratan learned additional advocate general. State respondent, as well as Mr. D. Pang, learned.
My learned friend Mr. Panging is for the private respondents.
D. Tamuk, learned counsel for respondent number?
5 to 16.
5 to 16. Here.
Here.
In appeal.
Mal.
Then we passed order in that writ petition. Huh?
Mal.
Writ petition heard Mr. No, we'll continue this. Although this writ appeal is tagged with the WPC 341 of 2025, let this matter be listed after disposal of the WPC 341/2025 as the WPC 341 of 2025 has been heard today, and the judgment is reserved. In WPC, in item 23, there is an item 22, right? In item 23, you write, heard Mr. T. Particular counsel for the petitioners, and also heard Mr. and Ratan additional advocate for the state respondent member 124, and Mr. Deepang Lana senior counsel assisted by MS Raj. Deepang Lana counsel for respondent 5 to 16. Yes. Judgment hearing concluded, judgment reserved.
Published.
May I please, my lord?
Yes.
My lord, I beg to mention item number 2, 3, 4, and 5.
2 is with 3, 4. 2, 3, 4, 5.
Yes, my lord.
Yes.
For listing of the matter before any other bench.
Why?
My lord has already given advice to the government.
Okay.
What
This is regarding?
land compensation.
Okay. That solution.
Yes, my lord.
Okay. 1, 2, 2, 5. List these matters before any other appropriate bench would agree.
Deeply obliged.
No, my lordship, I beg to mention item number 7. This matter will be discussed after summer break.
Why?
We have some person with
Who?
Lordship, this is connected to pension matter, lordships. Due to this recovery, lordships, recovery is not settled, lordships. The pension is not settled. There is one more case in this connected, lordship. So may please to take this matter, lordship. And Lordship,
Mr. Jeebam, learned counsel for the petitioner, submits that this matter may be listed along with WPC
537.
537 of 2025.
Yes, Lordship.
Lister.
Lordship picks that may be given, Lordship. Since the Lordship 2021, it's Lordship.
It's 2025.
Lordship, this case is of 2025, Lordship, but pension Lordship's widow Lordship.
MS.
Petitioner is a widow.
Wang State Council. Also praised for listing of the matter after 3 weeks. As Mr. Tapin, and on the ground that Mr. S. Tapin, the senior counsel, senior government advocate for some personal difficulty. Consider above, let this matter be listed after 3 weeks, along with WPC.
That may be given, Lordship.
Where is that?
Lordship, this urgent matter.
After 3 weeks, it will be listed.
Lordship on July, immediately after the break, Lordship. Because pension Lordship, pension matter.
3 weeks, it will be listed.
Much of. And interim may be continued Lordship in item.
Interim is there.
Yes.
Interim was that passed earlier, still continue.
Yes.
Yes.
Much of.
Item number 1.
May I please, your Lordship?
Yes.
Lordship, I'm challenging here in this petition, Lordship, basically the action of the respondents, Lordship. For not declaring the result, Lordship.
Of what?
Of benchmark for the disability person, Lordship. PWD's category, Lordship. What happened, Lordship? The APPSC, Lordship. But the respondent, Lordship, has published and has advertised on 17/9/2025, Lordship. For the common recruitment examination for the junior engineers, Lordship. 413 posts has been published, Lordship. And out of 400 JEs, Lordship, 22 has been reserved for the person with disabilities, Lordship. And out of 22, Lordship, 7 posts were kept reserved for the blindness and low vision, Lordship. And thereafter, Lordship, what happened, Lordship? After the advertisement has been issued, Lordship, the WPC 15 of 26 has been filed by the petitioner who are not even qualified in the examination, Lordship. The Lordship may kindly come to the writ petition filed by the petitioners, other petitioners, Lordship, that your Lordship will find it annexure 2, Lordship. Yes, Lord.
Your Lordship, this matter may be taken along with the pending writ petition number 15 of 2026 because the result has been kept in the seal cover because of sub judice of this pending writ petition, Your Lordship. In that writ petition, they have the petitioners they have put to challenge regarding identification of the post for PWD, Your Lordship. Therefore, the result has not been declared due to pendency of that writ petition, Your Lordship. So may I pray that this
is there any interim order?
No, Lordship.
No, there was no interim as such.
What is the difficulty in that case? What is the difficulty?
Your Lordship,
All the departments are required to identify the post. Also, the category of the disability will be put to that post. Since the department, many of the departments are done. Only the ratio of the quota for disability quota has been identified, but not the category of disability or who will be fit into them.
We'll issue notice that here. list along with those writ petition.
Lordship, in that case, Lordship may submit, Lordship. If your Lordship will kindly see the order passed by
No,
this
no,
honorable court.
see, when so these things are challenged, once we direct them to declare, that's true, there is motion will issue notice, that's all.
Otherwise, Lordship, that the writ petition, as the submission advanced by the Learned Standing Council for the APCS, Lordship, the present writ petition, Lordship, it has nothing to do with the WPC filed by the other petitioner who are not even qualified in the written examination, Lordship.
Okay,
Lordship, may kindly see the.
See, forget about that. Once the reservation, this thing is challenged.
Yes, Lordship. In that case, Lordship, the other reservations for other PWD's candidate, Lordship, their result has been already declared. Only in respect of 6 posts, Lordship, that has been kept under the seal.
We'll see. It heard Mr. Garam, Learned Council for the.
I'm sorry for interruption, Lordship. If Lordship may kindly fix this matter on next week to obtain instruction from the department, Lordship, for the.
And they'll say that this is spending, which better to list along with that writ petition.
So in that case, Lordship, this matter may be fixed on the next week, Lordship, along with the other writ petition, because I'll demonstrate that writ petition has nothing to do with this writ petition, Lordship. Because, Lordship, since the last 1 month, Lordship,
But
we have.
notice nothing else. All right.
Lordship.
What is that, the result notification?
Lordship. Page number 50, Lordship.
50.
Yeah,
by filing this writ petition, the petitioners have put to challenge the result notification dated 07/05/2026. Feedback. Secretary, Arunachal Pradesh Public Service Commission. Declaring the result of junior engineer. Result of the result of the junior engineer common recruitment examination 2025. Pursuant to the advertisement. Advertisement.
Yes, Lordship. Page number 21, Lordship.
Advertisement dated
17/9/2025, Lordship.
17/9/2025.
Correct.
For recruitment to the post of junior engineers in various department of the state. Particularly the result, particularly keeping the result of 6 posts reserved for blind and low basic candidates, 6 posts reserved for blind and low vision candidates under seal cover.
Lordship.
It is the contention of the petitioners that the petitioners are the specially able persons suffering from low vision, which falls under the reserved category of persons with benchmark disabilities under blindness and low vision. It is the contention of the petitioners that keeping the result for 6 posts reserved for PWBDs under blind and low vision category under seal cover. On the pretext of pendency of WPC 15 of 2026, when the advertisement that is 17/05/2025 has been put to challenge. Put to challenge, ignoring that the no order has been passed, no interim order has been passed in the said petition, debarring the authorities to declare the result of six posts of junior engineer reserved for PWCs under blind and low vision category, while declaring one post belonging to declaring the result of one post for PWBDs belonging to blindness and low vision category. Listener. Issue notice returnable by 4 weeks. 3 weeks, we'll make it 3 weeks.
That's my humble submission.
Mr. And Ratan Land, Edison,
Only the
Advocate General.
secretary has been made a party. I think
And
the petitioner will have to implic the concerned department also.
we'll see. And it's up to him.
Yes.
And Mr. for ARG for her, standing guardian, APPC on the respond, no comment notice will be. Should have an extra copies which are list the matter, extra copy, list the matters along with WPC 15 of 2025, 26.
In that case, Lordship, this matter may be kindly give a fixed date, Lordship, because
The urgency will see.
because Lordship, the other reserve category, other reserve category candidates results has been already declared, only for the civil post, Lordship. And whereas known as blindness, low vision category, Lordship, one post for the Department of Power has been also been published, Lordship.
Same,
Lordship, same category. Only 6 posts for the civil post has been kept in seal cover, Lordship. That's the logic I don't understand.
Civil post?
Civil post, we are from the civil categories, Lordship.
That is your case. We'll determine that, sir. All right.
But the reserve category for the low
It's
vision.
okay. We'll determine it. Maybe we should notice. We'll see what is their stand.
In that case, Lordship, kindly fix this matter on 27 July, Lordship.
Why you are,
Because for the last 1 month, all my friends, they already received their appointment letter and we are staying at home waiting for the result.
Are you
And
sure that you will be appointed? You will be selected. It's a seal cover.
That's what, Lordship.
Seal cover.
And if your Lordship will see the
Okay, after 3 weeks, give the date.
Lordship, 25 July.
It's not going to go away.
25 July is Saturday, it's only there.
27
Yes,
Okay, 27 July.
July.
Yes, Lordship. Item number 6.
Yes.
My lord. For straight 20 years, my lord, I have been fighting for my right, my lord. Yes.
So bad. So sad.
Without getting any justice, my lord.
What justice?
Without, my lord, getting any order, my lord. Be it bad or, my lord, good. My lord, what happened, my lord? Fact of the case is that, my lord, I have been in occupation of land measuring 585 square meter since 1981, my lord. Now I have applied for the allotted the area, my lord, 585 square meter. The authorities have, my lord, allotted me 350 square feet. And 235 was not allotted to me. out of 585, my lord. So I have again applied for extension of the lane, my lord. Page 40, my lord, 51, my lord. On 7/4/1994, my lord. I have applied for extension, my lord. Now the land is in my possession, my lord. Though the land is in my possession, my lord, the private respondent has applied for allotment of the area, my lord. So I filed complaint, my lord. Page 54 is my complaint, my lord. At that point of time, my lord, the Basar was SDO circle, my lord. Basar was a division, my lord, headed by the subdivision officer. Now it is a district. Since then, my lord, till 2022-21, my lord, I have been filing complaint after complaint, my lord. So no order has been passed, my lord. My last complaint is of 21 March 2022, my lord.
You may be,
I am in possession
you
of
might
land, ma'am.
have been occupied a certain area.
Yes, ma'am.
You have been allotted 350. That's
Yes,
all.
ma'am. Yes.
And rest has been allotted.
And then
to the
I have-
private respondents.
Yes, ma'am.
What's
And then
wrong? What's wrong? Just because you have occupied that all the land will be allotted to you.
So
Equally, they are entitled.
so there is an option
Other
of lottery, my
persons are
lord.
equal.
My lord, I have applied for extension.
Does it matter? You might have applied. What is
Yes.
your right that all areas should be given to you? Others, they also have the equal right.
My lord, there has been
How
some.
you are challenging that they should not be appointed?
There has
Just
been some
because
forgery, my lord.
You have occupied the land.
Yes, my lord. But there is an option of lottery, my lord, as per rules, my lord.
What lottery?
My lord, I have applied for the land. Subsequently, they have applied, my lord.
Then?
So there is, my lord, overlapping, my lord.
See, you have been allotted only 350.
Yes, my lord.
You have occupied 825.
585, my lord.
500. Rest have been allotted to two other individuals. It's
Yes,
okay.
my lord. Now there is some forgery, my lord. My lord,
What
please
forgery?
come
We
to
are not
verification.
Going to go
Page
into-
89, my
Oh,
lord.
once allotted. That's all.
My lord, may kindly see page 89, my lord.
Hmm?
Page 89, my lord.
What forgery?
This is the verification report of
How
the
do you go
Mondal, my
into
lord.
all these things? Hmm?
This is the verification report of the, my lord, Mondal, my lord.
So,
Serial number 2, my lord. Type copy is at page 90, my lord.
total it was given to me an area of 7.0.
Page 90, my lord. Serial number 2, my lord. May I read, my lord? See, Tajan Kamum is allotted 56 square meter area by order number so and so, so and so. However, as per record in the revenue register of this office, it is found that the then ADC Basar has collected area from 56 square meter to 144, my lord. So there has been some manipulation also, my lord.
Where is this?
Serial number 2, my lord. Page 90, type copy. Original copy is at page 89, my lord.
It's okay. What's wrong?
So, my lord, there has been some fraud play, my lord. Fraud play, my lord.
Not fraud. So it's corrected from 56 to 144. What?
So he was allotted 56, my lord.
Where it is?
Serial number 2, starting from Sri
No.
Tajan Kamum is allotted 56 square meter by order number so and so dated 15/11/2005, my lord. So government order is of 56 square meter, my lord.
Then?
But ADC has corrected it to 144, my lord, by hand.
Then?
So some fraud play was committed, my lord.
So how much it's remaining?
56 square meter is not big.
Where is the allotment order?
My lord, it is.
Where is the allotment order of this 56 and 144?
Yes, sir. Let me. Page 62 is the land passbook of the private respondent. 62 is the passbook.
62.
Yes, sir. This is only the front page of the passbook. May I propose one? May I suggest one thing? Let me file a fresh complaint on it, and a timeline may be framed so that within that period, the matter may be disposed of by the audit.
Necessary. Where is this passbook? Where does it indicate the area, total area?
No, it is not mentioned here.
Why you have not mentioned when you are claiming that
This is the copy. This is the copy of private respondent. I do not have any.
Who has annexed
access to?
I have annexed this.
Yes, ma'am.
And
This is what
how you access to only one page, first page?
I cannot access to everything, my lord, because this is a document of private.
How can we verify whether it's 144 or 56?
So why, my lord?
My complaint. Some officer has said it has been corrected. You said that the allotment is for 56, but it has been corrected and raised up to 144.
Yes.
What does it indicate?
This is not me, my lord. This is the Mandal, my lord.
Doesn't matter. Since you are relying on his statement,
yes,
or his verification,
yes, sir.
So you have to show us.
So, my lord, I suggest, my lord, I have a prayer, my lord.
Your suggestion.
I may be directed to, my lord, file a fresh complaint, my lord.
Your suggestion is not accepted.
My lord, there has to be some order, my lord, from
Who are you?
concerned authority.
Who are you?
I am a resident of Basar, my lord.
What resident? What is your occupation?
I am a retired government employee, my lord.
What government employee? Which post?
I have no more government employee, my lord.
No. Which post you have retired?
ADC, my lord.
Additional Deputy Commissioner.
Yes, my lord.
Big shot. Forget it. Petition dismissed.
My lord, I have not misused my authority.
Be happy with your.
I have never misused my power, my lord.
Huh?
I have never misused my power, my lord.
It's not the
to obtain the right, my lord, over the
question
land.
of misusing. You have been allotted 350.
Yes,
be happy with that. All right.
No, my lord, I am in possession of the land, my lord.
No,
but
you will direct you to Beckett. Will direct the authorities to evict you from those.
My lord, first I have applied the land, my lord.
Who is for the private respondent?
They are not appearing, my lord.
Notice has been served.
Yes, my lord. I have filed several complaints. At least that matter may be disposed of, my lord. That complaint may be disposed of. So that I have some remedy, my lord.
Proof of service. Huh? What disposed?
At least I should have some remedy, my lord. They are not disposing my complaints, my lord. Against the order of the DC, I can go to the secretary, my lord. So they are not disposing my complaint, my lord. Since 2005, I have been filing complaint on it. It has been said 21 years now. At least they should dispose my complaint on it. Be it in my favor or against me.
What is your stand?
Here, Your Lordship, in our affidavit, we are saying that petitioner was never been ignored by the department, Your Lordship, as the petitioner has been.
Is it so?
Yes, granted, Your Lordship.
How can he be ignored?
What he have been applied for in the year 1992, Your Lordship, petitioner has been allotted a set 350 square meter, Your Lordship, of commercial plot of land at Basar Market, as such on 14/2/1993. And Your Lordship, there was no records that petitioner was in occupation of the land measuring 585 square meter, Your Lordship. And there was no record with the respondent department that on 7/4/1994, petitioner has filed an application for the regularization of 235 square meter of land before the extra assistant commissioner Basar West District, Arunachal Pradesh, Your Lordship. This is our stand, Your Lordship. No application of petitioner for the allotment of lands is pending before the department, Your Lordship. And after the verification, Your Lordship, the matter has been become infraction, Your Lordship.
Matter has become infraction.
Yes, after the spot verification, Your Lordship.
Okay, why? How it's becoming?
Already, Your Lordship, the land has been allotted 350 square meter, Your Lordship, to the petitioner.
No, what is his case? His case is that he is in occupation of 585, and then he was allotted 350. He has applied for
He has applied for
extension
that.
of another 250.
And that was on 1994, Your Lordship. And after
then-
10 years, Your Lordship, and in our affidavit,
Then
Your
how
Lordship.
how these other the respondents were allotted?
Because the respondent were allotted in 19.
No application to
Petitioner
the
was
allotment
applied-
of land is pending before the department.
From our affidavit, Your Lordship, para 20, Your Lordship, page 119.
So you are submitting on the basis of para 16. After the verification, the matter has become in process.
Yes, Your Lordship. And also, Your Lordship, may come to page 20, Your Lordship. Here, what we are saying that there was no records, Your Lordship, as I have already mentioned. Respondent 7/4/1995 petitioner has filed an application for the regularization of 235 square meter of land before the extra assistant commissioner Basar Besyang district Arunachal Pradesh. Even if district land revenue and settlement officer DLRSO Basar Laparada district in the verification report dated 18/1/2022 has observed that petitioner has applied for the extension of land in the year 1994 and 95, Your Lordship. Whenever petitioner was sleeping for more than 10 years without following up his so-called application dated 7/4/1994. And it was only on dated 2005 petitioner has filed complaint, Your Lordship. That too against the allotted application of the respondent number 4. Moreover, filing of an application for the allotment of land does not confer any right to get the allotment. It is only the concerned authority who has the discretion to recommend and follow the allotment, Your Lordship. That's in our affidavit, Your Lordship.
Had Mr. B. Picha, learned counsel for the petitioner, and also had MS B. P. Pang, learned state counsel for the respondents.
My lord, my concern is only that my complaint may be disposed of, my lord. So that be it in my favor or against me, my lord. So that I have some remedy, my lord.
Why not the post office here? Why not the post office? You have filed an application, would that be any right accrued to you? And will direct them to dispose it. What's there?
They may dispose against me, my lord. They may pass order against me, my lord. Whatever may be the consequences, my lord, they cannot keep it pending for 20 years, my lord. By way of verification, they cannot dispose of my complaint, my lord. They have to pass an order, my lord. My prayer is this much only, my lord. Let them dispose of my complaint, my lord. Be it against me or in my favor, my lord.
Yes, what do you say, madam?
Respondent
Still it is
for-
pending, my lord.
He
For
wants
disposal.
that
Allotment has
his
been-
representation should be disposed of.
No, Your Lordship, case may be dismissed, Your Lordship. This case may be dismissed, Your Lordship, as already the petitioner have this one at 350 square meter, Your Lordship. Come.
Yes. The petitioner, by filing this said petition, has sought for a simple direction to dispose, for a simple direction for disposal of to the Deputy Commissioner, Leparada District, to dispose of his complaint against the respondent number 4 and 5.
Yes, ma'am.
Namely Sri Tajum Kamum and Sri Bomli Basar, in respect of the allotment of land, measuring 235 square meters in favor of the above two respondents, which is stated to be pending since when? Where is the
My first complaint is from year 2005, my lord. 4/7/2005, my lord.
Where it is?
54, page 54, my lord.
since 2005. This, you filed this writ petition after how many years?
My lord, there has been many complaints, my lord. Now, my last complaint is of date, my lord, of 2022, my lord. 21/3/2022, my lord. I have been filing complaint after complaint, my lord. Last complaint is of 21 March 2022, my lord. Page 97, my lord.
And the subsequent complaints, where it is?
Page 97, my lord. 98 is a type copy, my lord.
There is 21/03/2022. Next para. The case of the petitioner is that he was in the occupation of land measuring 585 square meters located at Basar Market Line near a staff canteen in the district of Leparada, Basar in the district of Leparada. This stuff. On the application for allotment, the petitioner was allotted a plot of land measuring 350 square meters by an order dated 15/05/1992. Christoph. Thereafter, the petitioner applied for extension of remaining 235 square meters, which was left out despite his occupation of the total area of 585 square meters, list of for which the petitioner applied for allotment of the remaining area of 235 by an extension. List of next para. Well, the application for allotment of the remaining area of 235 square meters was pending consideration, the respondent authorities have allotted the said area of 235 square meters to one Sri Tajum Kamum and one Sri and Sri Bomli Basir. Respondent number 4 and 5 here.
Yes, my lord.
List of next para. The petitioner submits that the petitioner contends that he has filed an application, a complaint on 04/07/2025. Thereafter,
2005.
on being not considered, 2005, huh?
Yeah, first.
And not being considered, he has approached the authorities from time to time and finally filed the last complaint on when?
21 March 2022, my lord.
21/03/2022. And with a legal notice, and thereafter a legal notice was also issued on 17/05/2022. Next para. Mr. B. Picha, Land Counsel for the petitioner. Well, initially, strenuously attempted to urge that the petitioner is entitled to be allotted of the remaining 235 square meter, which is in possession, which is under possession of the petitioner since 1981.
81, ma'am.
1981.
Yes, ma'am.
1981. Come on. What is it? Come on. Finally submits that and since the petitioner, the respondent authorities has failed to consider and dispose of his complaint, a direction may be issued to the respondent authorities to dispose of his complaint.
Within a time frame.
Complaints.
Yes, ma'am.
And list of her next para. MSP Pangu Learned State Council, while referring to the affidavit filed on behalf of the state respondents, submits that on the complaint of the petitioner, a verification was carried out wherein it is found, recorded, it is found that the petitioner was allotted as a plot of land measuring 350 square meter, whereas the 235, an area of 230 square meters have been allotted to the respondent, allotted in Februaries 1, 4, and 5.
Yes,
Therefore, the petitioner has no right to claim for the area which has been allotted to the respondent number 4 and 5. She submits that the petitioner has belatedly raised the issue as the complaint was of 2005 and the allotment of the petitioner, the respondents, when they were allotted,
it was 2005, ma'am.
2005.
No, to the respondents.
Yes,
in the year
2011-2005.
25. Therefore, the claim, if any, of the petitioner is also barred by delay and laches. Next para. I've considered the submissions of landed concept of the parties and also perused the materials of the report. Next para. Admittedly, the petitioner was allotted a plot of land measuring 350 square meters of land in the year 1992, and the respondent number 4 and 5 have been allotted an area measuring 235 square meters in the year 2005. List of the petitioner has failed to establish the area of 285 which has been allotted to the respondents, private respondents. And respondents that the said area, the said land is to be allotted to him. List of the land admitted is a government land, the state authorities, it is the domain of the state authority to allot the government land to an individual, the private individuals, in accordance with the provisions of law of allotment. List of no private individual can claim for allotment of the government land or mere occupation of the land. Rather, such occupation would be treated as an encroacher of the government land. List of in the instant case, the petitioners has been allotted an area of measuring 350 square meter, and the respondents, prime respondents have been allotted 235 square meters, which in accordance with the applicable rules, applicable act and rules, which this court finds no illegality in allotment of either of the allotments. In such in such circumstances, it would be prudent for the petitioner to stick to his allotted area rather to make an attempt to encroach the allotted land of the others. List of that apart, the claim of the petition appears to be still because the in as much in view of the fact that the allotment of the private respondents of an area of land of measuring area of 235 square meters appears to be was made in the year 2005. Please,
In respect to Manoj, may I, to respond our court,
it would be it would not be appropriate to reopen the settled issues. So it should reopen the settlement of the land in favor of the parties. Christoph, in view of the above, next para, the no relief can be granted to the petitioner as the petitioner has failed to establish any semblance of right or element of 231 square meters, which has been already allotted to the private respondents. Accordingly, writ petition stands dismissed. However, the authorities, the three commissioner may dispose of the complaint of the petitioner, but as may be permissible under the law.
That's observation then, Manoj.
That's observation. However, may dispose of as may be permissible under the law. These are all unnecessary things.
Item number 8.
Yes.
My friend for disposal of this item, Lordship.
Matter has become in process.
No, Lordship.
Yes.
Lordship, here the petitioners are the landowners whose land has been additionally acquired for construction of railway project. But their land has been acquired for, Lordship, construction of road over bridge, Lordship. Lordship, accordingly, notification was issued, public notification for land acquisition. And an assessment was carried by the Deputy Commissioner, District Administration. And first compensation bill was prepared. Thereafter, it was sent before the government for approval. And accordingly, the government approved for an amount, total compensation amount of 9 plus crore And it was sent back to the Deputy Commissioner with certain observation. That may I take you that order, Lordship, page 45. The order of the Director of Land Management, Lordship. May I read, Lordship? Page 45. With reference to your letter number so and so, 10th October 25, I am directed to convey you the government approval of the award for acquisition of additional land for railway line and ROB for the area of 22795.
Have you filed the affidavit?
Yes. We have filed. Government.
Central government?
Central government, Lordship.
We are for I don't think there is any necessity.
Central government from their side, Lordship, they have already released the amount. But here the acquisition process that petitioners are being aggrieved. After preferring of first compensation amount and on subsequent approval of the government. Now by this letter 14 October 2025, the government has written a conveyed about the government approval with a direction to the Deputy Commissioner that there are some discrepancies in the rate prepared for items, Lordship. Now, accordingly, in clause 8 of page 45, approval order, Lordship, the Deputy Commissioner Collector herself may, if necessary, re-verify the ground rate by engaging expert in the subject himself before finalization of award under section 37 of Act 2013. Now, Lordship, what happened? Thereafter, now Deputy Commissioner, without site verification, she has prepared the second bill, compensation report, Lordship. Thereby reduce the amount and some components had been removed from the list. First,
You have challenged that before the reference court?
No, Lordship. That is well, Lordship. Thereafter, immediately we have submitted representation before the Deputy Commissioner, saying that our representation has to be considered by re-verifying the site, Lordship. It was our prayer.
When the moment it was reduced?
Yes, Lordship.
When it was reduced the amount of compensation, then you file a representation.
Yes.
Then what happened?
Then representation, Lordship. Thereafter, Lordship, now they issued a notice for directing the petitioner to receive the compensation within 7 days. Otherwise, they are going to fork the amount before the designated court. It was the notice, impugned notice from the Deputy
They have already parked.
Regarding that also, Lordship, in their affidavit, 2 additional affidavit they have filed. They are saying that amount has already been forked. But our information through the learned district in session court
It's not yet been parked in the account of until how the process for parking the company is currently underway, and we are making effort to complete it.
It was yes.
How
Reply on 2/6, Lordship. Till 2/6, it was not parked.
Srestizar is why is saying that the process for parking amount is currently underway. We are making effort to complete it at least at the earliest. Parking is to by the authorities. Where the Srestizar is making an effort to get it parked.
In fact, no, Lordship. Lordship, we have submitted representation to the authority, of course, district judge. But letter has been issued from the
April. It's under process.
Thereafter, Lordship, on 2/6 also, Lordship, our additional affidavit. Reply was furnished on 2/6, yes. Where it says yet not, the parking process yet not done. With reference to your letter 28/5/26, I am directed
What is your ground?
My ground is,
Once
Lordship.
it is assessed,
Lordship.
award was passed.
Lordship.
Award was passed.
Yes.
After the award, this was reduced.
Yes. After award, then again second compensation bill was preferred. It was without verification, site verification. So our grievances in Lordship, there are only.
Was there a modified award?
Yes, it was modified.
Award was modified.
Modified, the amount was reduced, and at the first the item was reduced, removed some items, and then amount was reduced, Lordship. But without giving us opportunity, Lordship.
That's all. You provide them opportunity and reduce it.
Only
you reduce more. Give them an opportunity. Yes.
My lord, opportunity,
See, once the award is passed, how can you just reduce unilaterally?
my lord,
Wrongly or rightly? If there may be, this may be a wrong award, but there's a certain procedure has to be followed.
my lord, award, my lord, their main contention is that in the earlier award, where their compensation was higher, the subsequent award has reduced the components, certain components, and thereby the award has been reduced. My lord, this is their specific claim in this writ petition. My lord will kindly see the pleadings also. I'll take your lordship to the pleadings itself.
No, he's admitting that. See, what he's saying
my
is,
lord,
there was an award
Yes,
with certain amount, and by subsequently, unilaterally, you have reassessed and modified
my
the
lord, I'll
award.
explain that also.
Modified the award by reducing the amount of compensation entitled to the petitioner, without that too, of course, without hearing them.
My lord will kindly see page 16. The writ petitioner has, this is a continuation of para 8. Page 16. Writ petitioner, they have in the table, they have shown the
components. Yes.
shown the various first compensation amount and the second compensation amount and the amount of variation. In the paragraph below, it is their specific pleading that it is pertinent to mention that the Deputy Commissioner Pasighat, without re-verifying the ground realities by engaging experts in the subject as per directions, omitted various components from the compensation list, resulting into huge reduction in compensation amount, which was already approved by the competent authority. Now, in paragraph 18.
That too without giving opportunity.
Yes. In paragraph 18 also, it is the same contention that the second compensation assessment was prepared, thereby reducing some components from the first compensation statement, which was already approved and award was passed by the competent authority, resulting in huge variation. So and so. Paragraph 19 also says about without re-verifying the ground realities, the presence in presence of the affected landowners, reviewed the compensation assessment report, thereby reduce the components resulting in. Now, my lord, I'll demonstrate this, how in fact this acquisition process was initiated. My lord, in our additional affidavit in opposition, page 92. Additional affidavit in page 92.
You are not relying your affidavit.
No, my lord, in the additional, we have given more detail. Page 92. My lord, this was on 19 July 2023. My lord, I'll pause here. This was even prior to the notification for acquisition, the additional notification for acquisition. This was 19 July 2023. Here it says the Northern Frontier Railways under phase 2 of the NF railway project from so-and-so proposed to acquire land for construction of road over bridge at 2 Mile area Pasighat. Therefore, the following landowners of second miles are hereby requested to attend the meeting to be held in this regard at the conference hall, Deputy Commissioner on so-and-so, 25/7/2023 at 10 hours. Here, all the landowners were given notice. Then on 25 at page 93,
Yes.
Minutes of the meeting held on 25 July 2023 at Conference Hall of the Deputy Commissioner Pasigat so. A meeting in connection with the land acquisition for road over bridge at 2 Mile Pasigat pertaining to NF Railway Phase 2 from so and so was held on 25 July 2023 at this is Conference Hall, Pasigat East Siang District. AP. The following members attended. Here, even the petitioners, all the landowners, even the petitioners, they attended. At the very outset, ADC headquarter come chairman, assessment board, Pasigat circle of NF so and so, welcome the members and stress about the importance of the project and its relevance for the development of the region in particular and state as a whole. She emphasized on early completion of the said project and sought cooperation from the members present, especially from the landowners for smooth and early acquisition of the proposed area for construction of road overbridge. Then at page 94, further as deliberated by the members present in the meeting, it was decided. It was
verification.
Conduct ground verification on the proposed area to be acquired for construction of so and so on the same day on 25 July 2023 and to start the process of acquisition for the proposed ROB at an early date. My lord. Here on the same date when the meeting was called, on the same date, the acquisition process was, the site verification was done. Now, I'll take your lordship to the this writ petition again. Writ petition at page 35. Page 33 also addendum notification, my lord.
33.
Page 33. It is in the for the addendum notification. This is subsequent to this the earlier meetings for acquisition of the extra land for the road overbridge.
Yes.
Now, after this addendum, this was a notification, public notification was given. Then, since all the survey was done, my lord will kindly see.
It's okay. He's challenging the 29.
My lord, I'll now come to the reduction of components. My lord.
Come to that.
Yes, reduction of components.
Why this has been done?
Yes. Here at page 40. Page
What
40.
was passed on?
Award was passed, my lord. This was earlier, my lord. This was initially 1410, no, 1410 maybe. My lord, date. I'll come to the date, my lord. I will just compare whether there has been any reduction in the components, my lord. My lord will kindly see from page 40 onwards to page 43. These are the first page 40 to page 44 is the first assessment. And the second assessment will, my lord will see. Oh, so I'm so sorry. 47 to 47, page 47 to 48 is the second assessment. Now, at page 40, my lord I'll travel my lord in comparing. In page 40, serial number 2, Kaling Mangu, he is the petitioner number 1. He is the petitioner number 2. The description of items, my lord will see, NIM 3, quantity is 20, rate is 500, total so, betel nut, quantity is 80, pineapple, quantity is 500, so and so, cassava plant, so and so. My lord, kindly compare it with the second assessment at page 47 for this petitioner number 2 itself, whether there has been any reduction in the component. My lord will kindly see page 47.
Yes.
Page 47, my lord.
Quantity is the same.
Quantity is the same.
What has been reduced?
Only the rate has been reduced.
Okay.
My lord will kindly see page.
How, on what basis you have reduced it?
Reduced because there is a fix, the manual is there where rates are being prescribed, and for those items where there is no fixed rate, then by a committee, the deputy commissioner has constituted a committee and fixed the rate. So the basic question is that component has not been reduced, only the rates. My lord will kindly, I'll just demonstrate, compare for page 40 and 47.
Yeah, I've seen it. Rate has been reduced, not the component.
Not the component. No, nowhere the component, no one's component has been reduced. Only the rate has been reduced.
So,
now the rate which they have ascertained and given.
So
the
they are
question,
not challenging it.
They, if they want to ask for a re-verification, they are asking it only that the components have been reduced. That is absolutely no. Incorrect. Rates have been reduced. And whether the rates now, it is the quantum of the compensation, whether the rates is good or bad, high or low, that can be decided by a reference court. This is the components has not been reduced. They are asking for re-verification to decide the rate. There is no requirement of re-verification. It is the district, the authority who will, the district judge, who will decide that whether it is adequate or not, the rates. In the earlier, my lord, the NEEM 3, the rate was 500. Betel nut matured 4,000. Then pineapple 500. Now in the revised compensation, the rate, the NEEM 3 has been reduced to 220. The betel nut per plant has been 4,125. In fact, increased. Pineapple has, instead of 500, it has been reduced to 50. Cassava plant, 300. Ordinary tree commercial.
Earlier you said 1,000.
Yes.
300. Now it is 8,800.
8,800.
Then
bamboo per clump jati, it was 30,000. That has been reduced 10,500. 30,000 has been reduced, my lord. Quantity 22 rupees. Now the quantum of the items, whether these are in high or low, whether this honorable court will exercise that jurisdiction. It is for the authority to decide whether
the rates has been this thing.
Only the rates have been reduced.
Revised.
Only the rates have been revised, not the quantity. Why their prayer is for re-verification. When the quantity remains the same.
So that's it.
Now, even if my lord will say, even if today, if we accede to the direction, to the prayers, the petitioners are making that you go for re-verification. In our additional affidavit, why re-verification could not be done, that also we have explained. Because already the
For all the petitioners, the components are same. First or second?
Yes.
Both.
Both.
Only rates have been.
Only rates have been reduced. Some increase.
So what is the basis of reducing the rate? After not reducing, you have revised it.
Yes, revise it as per the manual and by constituting a board. The what is not provided in the manual that has been worked out and the rates have been reduced.
Okay.
In our
So
affidavit,
according to you, since the only rates have been reduced, there is no requirement of re-verification.
Yes.
Or a spot verification.
Yes. This
of the component.
Of the component, because the component has not been reduced. And in fact, this.
What is the difficulty in re-verification?
My lord, that I will come, my lord, in the report itself. Why re-verification could not be done? At page 101. That's in page 101. This is report in the matter of NF Railway Phase 2 project is Yang so and so.
101.
101. I'll not bother, my lord, why the rates have been decided and what rates have been fixed, my lord. These are all done by the board, my lord.
Only what is
Then revised rate, my lord. At 103. Why they go at para 15. However, there were many limitations to the above mentioned exercise conducted jointly by the district administration and DLRSO. One, due to ongoing panchayat election. Then second, there were changes observed due to abandonment of economic activity after initial assessment which was done. Therefore, in many cases, the plantations, plants, trees were dry and covered by weeds. My lord has seen. All members of the disbursement board could not be present in the ground due to shortage of time and non-availability of statutory order for reassessment. Many beneficiaries refused entry of the undersigned on site. Therefore, verification could not be done on proximity basis. So, without reducing the components, there was no component reduced because it was already abandoned and these economic activities were not done by the landowners. So, to protect their interests, re-verification was not done, reassessment was not done on the components. Had it been done, it could have been reduced more, maybe.
Reduce the items, components.
Yes, items would have been reduced, maybe.
So according to you,
we have not reduced their components.
But the rate, it would be the reference code will.
Reference code will decide the adequacy of the rates, whether these rates which have been given, that has to be decided by the reference code.
Lordship, may I take you to the page 40 of my annexure writ petition where I will show how the components has been reduced. My senior has overlooked this item. Lordship, page 40. This is Kalung Mango petitioner number 2 and third number, Lordship, pineapple. His quantity is page 40, Lordship. 500 quantity.
Pineapple.
Pineapple. Then Lordship come to the second assessment report, page 47. Pineapple part, it has been reduced from 500 to 315.
Hmm?
47. Likewise, in case of petitioner number 1 also, lemon plants.
Where is the second one?
Lordship, the second one is
second
page
one?
47. 47.
Calling Mango.
Yes. Serial number 3. Description of item in clause serial number 3 pineapple. It has been reduced to 315.
Calling Mango.
Yes.
Mango.
Mango. Earlier it was 500 and now it has been reduced to 315. And likewise in petitioner number 1 also, lemon tree, betel nut tree was earlier it was 500 and now it has been reduced to 271, and lemon tree earlier it was 400, now it has been reduced to 42. So like lemon tree, yes. Likewise,
Can the reference code not
400.
lemon tree has.
decide this matter also?
No, Lordship. Lordship, under section 64, what my humble understanding is, when the matter pertains to the measurement of land and the amount of the compensation, the person to whom it is payable, the right of rehabilitation and resettlement under chapter 4 and 6, and apportionment of the compensation among the person interested. In all these 5 categories, of course, the reference court have power. But in our case, Lordship, there is a violation of principle of natural justice. When second compensation assessment bill was preferred, and that too.
See, now there was no business, there's no activities after the first assessment. Even if you reassess it on the spot on verification,
Lordship,
it may further reduce also. Because you will have to revisit and see, because it's been years, I mean 2-3 years,
Lordship,
not under activities. So suppose 2 years back there may be 500, now it may be 20 pineapples.
Maybe, but Lordship, without spot verification now had randomly.
Now suppose if it goes,
Lordship,
if it's verified
yes,
today,
yes,
since there was no activities,
yes.
this pineapple and all other things may reduce. You want to take that risk or what? What they are saying is that there was no activities.
Yes.
So for the interest of the landowners, it may be, I mean, against to them.
Yes. But we are saying that that is against our interest, Lordship. At least they have to verify the ground.
So are you sure you have the still 500 pineapples?
Maybe, Lordship.
Then Mr. Additional Advocate General, you are wrong.
No, why?
Pineapple is 500 earlier, now it is 320.
Petitioner number 2.
Kalim, sir.
315.
We'll continue tomorrow. Find it out. What went wrong with your calculation?
Yes, sir.
Mr. K. Lowland, the petitioners, as well as Mr. and Mr. and Mr. Lunch, additional PP. List tomorrow for further consideration.
Reduction program.
Examine it.
Yes, yes. But in any case.
No. We just wanted to know. What's wrong with, what's wrong with your calculation?
It's the same number. Because I was
And
checking.
think about it. Better solution may come up tomorrow.
Yes, my lord.
District, there are only 5 petitioners in number, Lordship. It will take hardly 2-3 hours for re-verification.
What is other? Others are not, they're not interested.
Others, they have already accepted. The rest, Lordship, there are total more than.
I think they are wise people. They are more wiser than you. Yes, next.
Item number 9.
May I? I'm extremely sorry to inform that my senior has left this honorable court, as he was not feeling well, Actually, he went to pay last visit to the departed soul. Thereafter, he came back to the court and he's not feeling well. So I'm praying this matter may be listed on Monday.
What is the status now?
Status?
Same, Lord.
Same.
Same.
He is there. I'm hanging in between.
You are not there.
No, my lord. Because charges were not handed over to me.
Monday, then.
My lord.
Maybe it's filling.
My lord, since the pleadings are also complete, and since it is a transfer matter, my lord may dispose it of on Monday as a first item after the motion.
Will not say. We'll dispose it Monday.
Because Monday, I think there must be a reference at 3 p.m. So.
The reference was quickly on Friday. Okay.
Tuesday.
Last working day of the month.
Oh, obviously.
At 3:30. At 3:30.
Yes.
Mr. Aiba, learned counsel for the petitioner, submitted. Mr. Learned senior counsel, Mr. Arasir, who is leading in this matter, had to leave the court premises due to certain health issues. Therefore, praise for listing of the matter on some other day. Next period, as agreed to by MS and Learned Council for the respondent number
3.
3, as well as
1 and 2
Learned District Council. That this matter will be listed on Monday, 29.
There is an
interim order passed earlier is vacated.
If you will maybe continue.
Continue. Okay.
Item number 10.
May I please, your lordship?
Yes.
Lordship, here, service on steps by respondent number 8 still awaited. So I pray before your lordship.
And to take fresh step.
Fresh step, your lordship.
On the prayer, Mr. As prayed for by Mr. A. Bhattacharya, Learned Counsel for the petitioner. Fresh steps may be taken up, upon respondent number 8 within 2 days.
By Monday, I'll take
within a week. List the matter after 2 weeks. After 3 weeks. Yes.
Much older.
11 also.
11, it is a different matter. Here, lordships, I have taken steps upon all the respondent. Service has been completed.
Okay.
Here, your lordship, respondent number.
After if it not yet filed, we have respondent number 3, 4, 5, 6, 7.
Respondent number 7, 8, and respondent 11. They have filed their affidavit in opposition.
Okay.
The rest are yet to file their.
State.
Yes, we have filed, your lordship, for Forest Department and this one Land Management. For Deputy Commissioner, we need some more time, your lordship.
And Mr. A. Bhattacharya, Learned Counsel for the petitioners. Petitioner.
I'm for petitioner, your lordship, only sole petitioner.
MS P. Pang, Learned Counsel for the petitioner, request for and is granted 3 weeks time to file affidavit. On behalf of the Deputy Commissioner.
Yes, your lordship.
Respondent number.
Your lordship, last chance may be given for since more than 1 year.
Yes.
This is pending, your lordship.
No. the Deputy Commissioner?
Respondent number 6, Your Lordship.
Respondent number 6. List
And
after
rest
3
we have
weeks.
filed.
List after 3 weeks. Yes.
Much obliged.
Item number 12.
This matter, Lordship, the Deputy Commissioner has already filed their affidavit, Lordship.
My lord, I am for respondent number 3 to 6 on it. Private respondent.
You want to
Recently I have filed my wakalat now.
Okay, heard Mr. T. Garamlan, Council.
4 weeks, my lord.
Petitioner. Is prayed for by Mr. B.P. Chalan, Council for the petition, respondent number?
3 to 6.
3 to 6, praise for it is granted. 3 weeks time to file affidavit.
Lordship, I'm for 1 and we are not filing affidavit.
You are not filing. MSNA and you learned council, standing council,
Standing council, election.
PPSC, election commission. Submitted, no affidavit is required to file on behalf of the election commission. Then you also,
We have five.
MS Arbasel and state council submitted affidavit is already filed on behalf of the state. List after 3 weeks.
Deeply obliged.
Item number 13 and 14.
Bloom Jinda. Yes.
Mayor Lordship, here the Senior Advocate M. Datta is appearing for the respondents. So he's from outside. So the man matter is listed for the 22nd of 7th, 2026. So maybe listed on same date.
When? 27?
22nd of July.
July.
Yes.
My lord, I'm challenging the impugn order, my lord. I mean, why with the debarment order has been stayed, my lord. This is an IA for vacating that order, my lord.
Yes.
Order that at 10/6/2027, my lord.
We'll have to issue notice.
I have, my lord, since Mr. Mo is not here, my lord. In fact, I've tried to contact him, my lord, but then he's not available. I've been informed that he's out of station.
Mr. Mo.
Mo, he's hearing.
She's there.
Actually, my name is not in the court list.
Wakalan number, so.
So we
You are
couldn't.
junior, you are authorized to.
She has declined.
Actually, I haven't.
No, you take. Then in that case, we'll issue notice.
My lord, and then my lord, it can be heard, my lord, because.
No, without them, how can we?
Therefore, my lord,
We'll issue notice.
my lord.
Heard Mr. Opada learned counsel for the applicant. Next para, this application is filed for seeking vacation of the impugn order dated 10/06, seeking file for praying for vacation of the vacation of the modification or alteration of the order dated 10/06/2026 passed in WPC 225 of 2026. Mr. Next para, issue notice returnable by 2 weeks.
My lord,
Actually, it's fixed on 22nd July.
I mean, it is fixed on 22nd of.
Then we'll say the 3 weeks. Next para, learn counsel for the applicants to take steps for service of notice upon opposite party writ petitioner, right?
My lord.
By registered board or
my lord, if my lord says, my lord,
Actually,
I can
we are just a local council. They are in Delhi. So
Now, if that, it makes it so difficult for us.
your name is there, no?
no, my name is not there. I'm on behalf of SMO.
You appear, it's okay. Mr. Mo is there.
He's there, but he's not
you are
appearing in the
there,
matter.
it's okay. No,
Senior counsel is appearing in the
it's all
matter.
right. But his name is there.
My lord.
Issue notice returnable by 3 weeks. Next para. As MS Tisomo, Learned Council appearing on behalf of Mr. Esmo, Learned Council by opposite party represent access notice on behalf of the opposite party. No permanent notice need this. However, copy of the drill application be furnished to MS Tisomo.
My lord.
It's okay. You are authorized. You are his junior.
I'm sorry, my lord, the item number 1, instead of 27, the pattern may be fixed on 3rd also. I have some personal difficulties. I have taken consent from the respondent.